Okay, good morning, everyone. Welcome to the 18th Annual Dean's Diversity Forum. I am Andre Cummings, the Dean of the Law School here at Widener Law Commonwealth. And for 18 years, we have hosted at Widener University Commonwealth Law School a diversity forum. We were founded in 1989. And one of the reasons that we were founded as the Harrisburg campus of Widener University was to provide an opportunity for access to justice. There was a sense in our legislature that there needed to be a school that would provide evening education to folks here in Harrisburg that were interested in a legal education, and also to provide access to justice to central Pennsylvania. And so we've been since 1989 educating students to provide access to lawyers and justice throughout the state of Pennsylvania. 18 years ago, before the word diversity became controversial, or as controversial as it is today, we felt like it was really important to talk about issues of diversifying the profession and providing an opportunity or a pipeline or a pathway for folks that had been previously shut out from legal education an opportunity to gain one. And so today, what we hope to do is Difficult Conversations, Equitable Inclusion is the name of the title of our program today. And what we hope to do in our two panels that we will present is, in panel one, we'll talk about why it's important to have difficult conversations, why it's important to be able to do so civilly, why it's important in this era and day and age to be able to disagree agreeably and to be able to talk about things that are hard. So we're going to try and talk through in panel number one why it's important to have difficult conversations. In panel number two, we're going to try to model what panel number one presents to us, where we're going to attempt, and I hope successfully, to have a difficult conversation and to have it civilly and to be agreeable in modeling difficult conversations, where we're going to talk about equitable inclusion and whether it remains important to try to continue to diversify the profession and provide access to justice throughout the state of Pennsylvania and throughout the nation. So that's why we're here today. I want to welcome those that are joining us on Zoom and everyone in the classroom. What we're going to start with today is we have our student leaders of various affinity organizations here on campus that are going to talk to you and welcome you and talk a bit about what their organizations do and why inclusion is important on a going forward basis. So we're going to hear from our student leaders before we begin panel number one, which is engaging in practical pluralism, or how to have a difficult conversation. So I would like to bring up Gabe Kuehn. Gabe is a Center Fellow for the Center for Equity and Justice here at Widener Law Commonwealth. He and I and Professor Miss-Kye have been working really hard together as the Center for Equity and Justice was founded here this academic year. And I would like to turn the time over to Gabe Kuehn.
Hello, everyone. As Dean Cummings just said, my name is Gabe Kuehn, and I am a second-year law student here at Widener University Commonwealth Law School. I work for Widener's Center for Equity and Justice as a Center Fellow, along with Eli Ziegler, who will be moderating the first panel this morning, and Tara Smith, who will be moderating the second panel this afternoon. The Center for Equity and Justice is one of the newest organizations at our campus, but it is undoubtedly one of the most important. The center is dedicated to promoting justice and creating equal opportunity for marginalized communities within the legal profession. One way that we help achieve this goal is through our Pathway program. The Pathway program is a 12-week LSAT instruction prep course supported by over a $300,000 grant, which was donated by the Law School Admissions Council, or better known as the LSAC. This program is provided free to students based upon the LSAC grant. The Pathway program aims to help uplift students from populations that have been historically discriminated against, first-generation students, students from rural areas, and students who may have little resources to adequately prepare for the LSAT. The Pathway Program seeks to break down these barriers and make sure that students who want to enter the legal profession have an equal opportunity to do so. In addition to the Pathway Program, the Center for Equity and Justice has recently partnered with Walmart for an enhanced community policing project. This project analyzes policing practices in low-income areas with the goal of improving community-to-police relationships. The research in this project will focus on retail theft of necessities such as food and baby diapers and how law enforcement should justly handle these situations. This is important work that needs to be done, and Widener is moving in the right direction. The Center for Equity and Justice also helped plan this event here today, and I thank you all for your attendance, both virtually and in person. I hope you all enjoy the 18th Annual Dean's Diversity Forum. Thank you.
Next, it's my pleasure to introduce the president of our Black Law Students Association, Miss-Kye Gallen. Miss-Kye.
Good morning. My name is Miss-Kye Gallen, and I'm honored to serve as the president of the Black Law Students Association, also known as BLSA, here at Widener Law. As a third-year law student and a future assistant district attorney, I'm committed to fostering diversity and inclusion in the legal profession. BLSA is dedicated to the academic, professional, and personal development of law students. Our mission is to create a strong, supportive community that promotes excellence, leadership, and advocacy. We strive to ensure our members have access to membership, resources, and opportunities they need to succeed. One of our biggest goals this year is to ensure that every student in the organization secures an internship. Internships are pivotal in shaping career choices, providing real-world experience, and building professional networks. We are actively working to connect our members with opportunities that align with their interests and career aspirations. In addition to career development, BLSA is proud to have established the first student organization-run library at the school. Thanks to generous donations from alumni and upperclassmen, we provide casebooks and study materials to students at no cost, operating on a check-in and check-out system just like a traditional library. Our library also includes an extensive outline bank, offering course outlines from past students to help current members navigate their classes and prepare for exams. We also host study sessions to support students who need extra guidance in challenging subjects. Beyond academics, BLSA is committed to creating meaningful experiences on campus. Later today, we have our first ever fashion show. In the coming weeks, we will hold our annual field day, bringing students together for a day of fun and community building. Earlier this semester, we partnered with the NAACP Harrisburg branch for a back-to-school drive, and we also worked with the Langustown Middle School to speak with 8th graders about what it's like to be a law student. BLSA is proud to be part of this year's Dean's Diversity Forum, and we look forward to working together to make the legal profession more inclusive and accessible. Thank you.
Thank you, Miss-Kye. Miss-Kye is a force of nature. And are you heading back to New York, Miss-Kye, to work? Yeah. Did you say where? In what capacity?
As an assistant.
As an assistant DA. So we're proud of Miss-Kye. She will be fantastic. Next up is Kimberly Diaz. Kimberly is the president of our Latin American Law Student Association. Her organization, she'll probably mention this, I don't want to steal her thunder, but just last week held a Know Your Rights forum here in this room that had over 75 or 80 folks here. And her organization has hosted Muerto de los Day of the Dead, and has had a really strong presence here at the law school, just as Balsa has. So, Kimberly, please. Dia de los Muertos. There we go.
Good morning, everyone. My name is Kimberly Diaz, and I am honored to be here today as the president of the Latin American Law Students Association, also known as LAWSA. Our organization is composed of 11 passionate, dedicated e-board members, all working together to create a supportive and engaging environment for our members and the broader community. LAWSA's mission revolves around promoting the intersection of Latino culture and the law. We strive to provide a platform for the exchange of ideas, fostering both the professional and social success of our members and alumni. We welcome anyone who's interested in learning more about Latin culture and the legal issues facing our communities. Our efforts extend beyond the walls of our organization. LAWSA provides educational events, fostering networking opportunities, and encourage advocacy for underrepresented groups. Some of our key events include the Latinx Attorney and Judges panel. This panel brought together 8 distinguished Latinx attorneys and judges who shared their wisdom and experiences. Their insights were incredibly inspiring and provided our students with valuable guidance as they navigate their legal careers. We also hosted, as Dean Cummings has mentioned, our Know Your Rights event, where we educated students and the community on their constitutional rights. It is important to us that we provide resources that empower others to understand and protect their rights. LAWSA is more than just an organization. It's a community. LAWSA has taught me the value of community and the importance of supporting others, whether academically, socially, or professionally. The leadership and organizational skills I have gained through LAWSA have equipped me to make a positive impact, whether it's through mentoring, advocating for underrepresented groups, or expanding access to legal resources. Thank you for giving me the opportunity to share a bit of about our organization. LAWSA is an incredible space for growth, connection, and empowerment, and I'm incredibly proud to be a part of it. Thank you.
Kimberly also is a force of nature. We're fortunate to have her on campus. And after you graduate, where are you headed, Kimberly? Going to New Jersey with the judicial clerkship. We need to do better at keeping our people here in Harrisburg. Well done. Thank you, Kimberly. Next up, the secretary of our Asian Pacific American Law Student Association, Emily Corcuera, will come up, please. Emily.
Good morning. Thank you for coming. My name is Emily Corcuera, and I am Secretary of the Asian Pacific American Law Student Association, or APALSA. I am Filipino-American, half white, and half Asian. I never felt like I fully fit into the Asian community because I didn't feel Asian enough. Joining APALSA for me was about embracing my Asian heritage and ensuring that everyone in my community felt seen. For me, it's about empowering our community and making sure that we are represented in all areas of the law. APALSA was brought back to Widener last year by President Ashley Varghese. She noticed that there was a gap in the Asian and Pacific Islander representation here at Widener, and she worked to revive that organization that once was, and I am extremely grateful that she did. Our goal is to ensure that our members have community here at Widener, so they don't feel alone within their legal journey. But we also want to let them know of the opportunities that await them once they graduate. Not only in the specific area of law, but also knowing that they are represented through an organization similar to APALSA, through the Minority Bar Committee of the Pennsylvania Bar Association. We have been extremely grateful to partner with the MBC on 2 of our events this past year. Last semester, we brought in 2 MBC members to discuss how they grew their professional network and provided tips to our students. As law students, we're told that networking is an important aspect of our careers, and yet one of our members pointed out that some of us don't know how to network. So we brought in those MBC members, and it was a great opportunity for us to learn how to grow our professional network. In this semester, we coordinated with another member of the MBC who was able to bring in 4 other women who have worked in various positions throughout the Attorney General's office and the Office of General Counsel, Our purpose with this panel was to show that there are other opportunities within our community, that you don't have to take the traditional legal route, and there are ways to help people not through those traditional legal routes. We are hoping to continue our relationship with the NBC next year by creating a networking event between APALSA and members of the Minority Bar Committee. We also wanted to educate our community on issues surrounding us, so we put on an immigration panel to discuss such an important issue within this country. This was before the election, so we were able to discuss what the different outcomes would look like, and we were able to give a perspective on an issue that is much deeper than people realize. I am extremely grateful to be a member of APALSA because it brings me closer to those in the Asian and Pacific Islander community, not only within Widener, but those who have come before us and helped make our experiences better. APALSA has not only brought me into contact with former APALSA members, but with members of the minority community whose aim is to make all feel seen and welcome. Representation is important, and if we can help someone at Widener feel not only seen by the events we put on, but by our organization as a whole, I think we've accomplished our goal. Thank you.
Emily serves on my Dean Student Advisory Council and has been a fantastic presence here at the law school. And I think that you can see that our student organizations are in excellent hands with Miss-Kye, Kimberly, and Emily as we work hard here to make sure that this is a place where everyone feels like they belong and have a place and are seen. Okay, so let's begin the festivities of the day with our first panel. I'd like to invite all of our panelists to come up, please. And as they do, I will introduce Eli Ziegler, who is our moderator for this session and one of our center fellows at the Center for Equity and Justice. I'm proud of Eli as a second-year student. Go ahead and take your seats, panelists, please. I met Eli before I even started as the dean here at the law school. Come on up, Eli. As Gabe was suggesting earlier, our Center for Equity and Justice has a pathway program, and what I needed in this pathway program were expert LSAT instructors. That was going to be important for me to find folks that had done very well on the LSAT, that had some teaching background, and so Eli for the last summer and this summer upcoming is an LSAT instructor as part of our pathway program. What Gabe didn't mention is that we, Widener University Commonwealth Law School, has been hired by LSAC to run their Guided Journey Plus program summer LSAT preparation, which will include 800 LSAC scholars all looking to become law school students that are hoping for instruction on the LSAT. And so Eli will be instructing 4 of those 25 cohorts this summer. As well as being the supervising instructor. So he's going to lead the 9 other instructors that are teaching these 850 students, mostly first generation, mostly from marginalized communities, as an opportunity to assist their entree into law school. So he's been a fantastic center fellow, a great LSAT instructor, and now we'll see he exercise his moderating skills. So Eli Ziegler.
Yeah, we'll see. All right. Well, thank you. Dean Cummings, thank you so much. I thought I'd get to come up here and speak, but now the pressure's on. But that's all right. So thanks everyone for being here. I'm going to introduce this panel in just a few moments, but I do have to get a couple things out of the way first. The first is that I'm notoriously bad with microphones, so sorry if we get a little feedback, I'll adjust. But the second is I just want to reiterate what Panel 1 is and why it's important. And as the moderator for Panel 1, I have to believe that it's the more important panel, and Tara will say that Panel 2 is the more important panel. But what we're doing here is practical pluralism, and as you heard Dean Cummings say, and when I was in communication with the panel, that is the how and why of difficult conversations, and that is how I marketed it to these 4 who so graciously agreed to be here. So thank you all again. We'll get to who the people joining me are. But the how and why of conversations really is the playbook, and that is what panel one is. It's the formula so that you can take it anywhere. And panel two is going to be, again, an example of what that can look like on a difficult conversation, and that's the Equitable Inclusion panel. But the goal is to give some tools here and to talk about things and really give a perspective on what makes it, why is it important to have these conversations and how to do so. And so you'll hear me say difficult conversations a lot, and you'll hear me say how and why of difficult conversations a lot. That really is the focus. And the reason for the practical pluralism and why that is the topic for panel one is because how and why seems like a pretty good topic for the first Deans of Diversity Forum. We are now on the 18th. The reason it's important now is because we find ourselves in, whether you think it's warranted or not, it's a pretty divided time. It's hard to have difficult conversations. There's a lot of difficult conversations to be had. And so when we were thinking about what we wanted this panel to be, that was the reason that we found ourselves on equitable, or on the practical pluralism. And so with all that being said, I'm joined with four lovely panelists. And to my immediate left, we have Professor Miss-Kye. I'll keep these introductions short and sweet, but just know they could be 10 times longer. These are very decorated people. So Professor Miss-Kye is a sought-after expert on legal ethics, professionalism, and lawyer regulation, and has published articles on those subjects. Prior to her arrival at Widener Law Commonwealth, she was the director of the Transition in Law Practice Program for the State Bar of Georgia. In a previous role, she was Associate Dean of Students and Associate Professor at Savannah Law School, where she taught in areas of legal ethics, civil procedure, and alternative dispute resolutions. Before entering academia, Professor Miss-Kye served as Assistant General Counsel for the State Bar of Georgia, litigating lawyer disciplinary cases and providing ethics advice to lawyers, law students, and paralegals. To her left, we have Professor Hussey, who I might accidentally call Dean Hussey. We will get to that, but he was my dean for a year, so it only makes sense. Professor Hussey teaches and writes in areas of taxation, business organizations, wills, trusts, and estate planning. He's the founding director of the law school's innovative business advising program. Professor Hussey is devoted to preparing students to advise business clients as practicing lawyers. Professor Hussey is the faculty director of the Volunteer Income Tax Assistance Program. In this program, students and alumni prepare tax returns for low to moderate income taxpayers. Professor Hussey has won the law school's Teacher of the Year award, and he served as the dean of this school from 2021 to 2024. Thank you for being here, Professor Hussey. To my right, we have Professor Luna. Professor Luna is an internationally recognized scholar whose teaching areas of expertise include property, agricultural law, jurisprudence, and remedies law. Professor Luna has written numerous law review articles and book chapters, including entries in the Encyclopedia of Latina and Latino Politics and Social Movements, and an extensive bibliography on the Treaty of Guadalupe Hidalgo, both published by Oxford University Press. She is an elected member of the American Law Institute and is an American Bar Association Fellow. Professor Luna served as law clerk for the Honorable Theodore McMillan on the Eighth Circuit Court of Appeals. Professor Luna received her bachelor's and JD from the University of Minnesota. And last but certainly not least, to Professor Luna's right, we have Dean Conway. Dean Conway is the dean at Penn State Dickinson Law, a leading expert in procurement law, entrepreneurship, and intellectual property law. She served for 4 years as dean of the University of Maine School of Law and 14 years on the faculty at the University of Hawaii. Dean Conway's scholarly agenda and speeches have focused on advocating for public education and for actualizing the rights of marginalized groups and promoting systemic equity in legal education and the profession. Under her leadership, Dickinson Law's Anti-Racist Development Institute was created to implement anti-racist practices, processes, and policies throughout organizations. She is an elected member of the American Law Institute, a member of the AALS Executive Committee, and a director of the Access Lex Institute. So this is our panel. Let's give a round of applause and not hit the mic again. Again, thank you all for being here. And I'm going to try and lower this and probably need Brian's help because it looks different from when he showed me how to lower it. I'm sure. Oh, wait, I have experts. I guess that was Bryant, because it wasn't me. All right. I did let the panelists have the option of having opening remarks. And so we are going to hear from Professor Luna and Dean Conway before we get started on anything else. Dean Conway, if you would come up here and present your piece.
So, Professor Luna's not going. Okay,
Reorder,
good.
yes.
Thank you. Well, good. Okay. Well, good morning. Good morning. Good morning. Good morning. All right. I'm going to ask everybody that's sitting here to go to the middle.
I appreciate that. This is all right if we just have
Oh,
this.
fantastic.
Awesome.
I don't,
All right.
Actually, just leave it on the first page because I don't need to. There we go, because that's pretty.
That is pretty, actually.
Okay, why did I do that? Anybody, why did I do that? Yep. Why did I do that? For the folks who are sitting. Come on, let's get this going. Why did I do that? Anybody, I'll make whatever you say correct. I tell my students all the time.
So that we were all in front of you and we were all sitting together and not divided.
Exactly. That's exactly right. And the other reason why I did it was to see how well you might actually respond to a request/directive. Right? So yes. And so that we can be more communal, right? That's the objective. So I'm not going to belabor it, but what I'm going to say is thank you for being responsive to it. As well, our panelists want to connect with you. They want to see you and not have you in the back of their frame. So that's important. And in the spirit of inclusiveness, all of our Zoom community, welcome and thank you for Zooming in and being a Zoomie. There's nothing more exciting than being a Zoomie. All right. I look at what Professor Luna and I are going to do as creating a framework. And I was particularly appreciative that this message was delivered as we started the conversation. I actually refer to this not as the why and the how, because why creates a sense of judgment, right? So anyone's why can be their own observation. Rather, this framework is a what and a how. Those questions are a bit more objective, a bit more fact-based than the why and the how. And it is the question of the what and the question of the how that animated me when I began this conversation amongst our colleagues at Penn State Dickinson Law and our colleagues in the entire legal academy in 2020 after the murder of George Floyd, with a statement about what we all felt about racial injustice, what we felt about our obligations as members of the legal academy and the legal profession to be responsive. So as we were having those conversations, it became abundantly clear that these two questions of the what and the how were rising up. As people began to talk about, well, what does it mean to be anti-racist? And how do you expect any of us to do that? Those have been the animating questions over time immemorial. How many times have we heard people say, I'd love to do that, but I just don't know how? Raise your hand. Right, love to do that, but I don't know how. Which is a bit of escapism. Because if I say, well, I don't know how to do it, nobody taught me that, then I have a built-in excuse. And so it is that excuse that we were trying to address. And I always found that quite interesting, that the brilliance with which I am surrounded, law professors, are actually disclosing, probably for the first time ever, I don't know how to do that. I don't know how to do anti-racism. Nobody taught me that. So that was actually, I think, liberating, but I also found it quite sensationally humorous. That people are trained to teach, do not have the capacity to learn. And so this is why the framework is so important. The title, Building an Anti-Racist Law School, is really not important. It was the approach that we used to answer the questions of the what and the how. And so that's what I'm here to do, to deliver that approach. So that approach was to use a design thinking method to address how we approach a topic like teaching and learning about anti-racism. Because you don't just wake up and go, oh, today I'm going to teach and learn about anti-racism. We might as well say that about torts, civil procedure, evidence. Today, I'm gonna be an expert in teaching and learning about those topics. If that happens to you, run fast, because you don't need law school. You're good. Take that bar, get on up out of here. But we know that's not how it happens. So this design thinking method actually provides us this opportunity to address the what and the how. So I'm going to give you the elements of design thinking methodology, again, separate and distinct from the subject matter of whatever you're dealing with. It's first being empathetic. To engage in empathy requires the identification of a user, a person. Why is that so important? It is important and actually antithetical to what we're teaching you in law school. It's important because we don't think about individual users or people or what they bring to the table. The first thing that we teach you in law school is identify the issue. What is the issue? Give me the jurisdiction. Where am I legal writing? Yep. We're not blaming them. We asked them to teach this way. What's the jurisdiction? What's the legal question? What are the legally significant facts? How many have heard those three things? Raise your hands. Do we say, let's begin with the empathy of the user? Who's done that? Right. Thank you for telling the truth. Because sometimes you do this presentation and folks raise their hand. You're like, come on now. Do not make me call you out. We don't begin with the empathy. So that is the first thing in design thinking. The second element in this framework is to then ask the question, what is the individual's pain point? Do we ask that when we? No. What is the pain point? What is that user experiencing? Wow, right? The third element in this process is not to do what we train you in law school to do. Let's solve the problem. Instead, we pose a question with the knowledge of that empathy and that pain point. Let's pose a question or even a series of questions about actually how to acknowledge that individual and that pain point. And then and only then do we enter into what we most understand in the law, this ideation phase. How do we ideate to be responsive to that question that is premised by the pain point and the individual? And only then, in this method or process, do we say, let's think about solutions that respond to the ideation. Then, let's test it out. And finally, let's get feedback. And then, to make you understand that this is not a linear process, we actually ask you to go through it again. So if you read this very brief article that introduces you to systems design and design thinking, what you will see coming up in your conceptualization of this conversation is this infinity. We ask you to restart again and again, and that's called iteration. And I posit to you that this is a building of a framework that allows us to be more empathetic and more considerate of the speaker in front of us, of the person who has a disagreement or a discord about what it is we are discussing. It gives you an actual framework for evaluating what we are discussing. See how I landed on that? What? Instead of the judgmental, why are we discussing it? And we as lawyers have the ultimate responsibility to actually keep the conversation going, not to shut the conversation down. And that's very consistent with design thinking because, again, this infinity is doing what? It's keeping it going. It's getting us to frame and reframe and then continue to frame and reframe various questions. So this is an approach and a framework that we have incorporated at Penn State Dickinson Law in delivering on our core value of becoming an anti-racist law school, because we are always in a state of becoming. That too speaks to the iteration. So I hope that when we further discuss the what and the how, that actually helps us today with our first panel, building on that, I know you will, Professor Luna, and also the second panel for practicing. What is this, y'all? Yeah, the infinity loop. Say it all together. I want to hear cacophony. Yeah. Come on, you can do better. One more. Exactly. Thank you.
I should say when I was preparing for panel one, I knew I'd be outclassed intellectually, and it didn't dawn on me until right now that public speaking, another area in which I'll be outclassed and have to try to keep up. Thank you, Dean Conway. And I'm glad you said that. It's more about not just how and why, but there's the other W's, the who, what, when, and where. And I did expand some of my questions into that avenue, and I'm glad you brought it up for me because it's important. And I am, there we go, going to pass the podium over to Professor Luna. The podium is yours.
Good morning, good morning, good morning. Welcome, everyone. Thank you for coming. Let's see if I can manage this. My job is to offer you a conceptual framework. And so I approached it from, here's my roadmap. You'll have to bear with me because I'm still learning this method. Eli, help me. How to...
There you go.
Thank you. So my first emphasis will be jurisprudential. driving from the philosophy of law. I remind my students we are getting a JD, right? Juris Doctorate, philosophy and law degree. And in law schools, commonly, we focus on legal formalism as a way of teaching. I'm going to add to that in a minute or two. I'm going to underscore, while we're studying rules of law in law schools, that DEI is a policy and not a rule of law. So without resolution, this is slide 2, we're going to see a situation, for example, and I'm going to give only 3 or 4 slides as a general framework. Without resolution, what do we have? We have the status quo, correct? The status quo does what? It does nothing but maintain harmful structures. Give you a list in front of you. Just learning law from top-down approaches gives us sledgehammer approaches that produce a lot of harm, for example. It equates with top-down learning and mandates all sorts of horribles, as we're seeing with this anti-DEI framework in the present, all sorts of false norms that are coming out of it, all of it based on false premises, and what happens then, it becomes reified. We see all sorts of harmful stereotypes erupting all over the place, used as a weapon against so many enterprises that are out there, law schools, institutions, all sorts of educational institutions that really are problematic and bothersome. We see that some of the harms extend to creativity. We cannot see creativity unless you jump outside of that norm, as we're seeing at Dean Conway School. We see then by default that the status quo prevails, and then the bottom line is so harmful that nothing transforms. It's not a transformative event to learn top down. I'm not saying that it's the only way to, that it's harmful to learn top down. We have to do that. That's imposed on us in law schools, unless you go to Dean Conway's school. Now, as lawyers, and that's why I'm taking this jurisprudential approach, as lawyers, we're always chasing truth and facts. That's what we do. We're closely aligned with the scientific world. A lot of us keep digging and digging and digging for truth and facts. The only problem is that when we're in a room like this one, there's a lot of differences here, right? There's generational differences, there's political differences, historical differences, language differences. We're lawyers. Language plays a big role in our community. There are racial, gender, class distinctions. And so that's when we get into trouble when we're engaging top-down conversations. Some of the tools that I've come up with, and I'm not the first one to do this, is that I have to admit to you, it's in my DNA. I was always raised to question the status quo. What does it require? The tool here is that we have to unlearn what those myths are that are being told to us every day in the media, newspapers, for example, a lot of false truths that are out there, falsehoods. So we have to unlearn them. And what we have to do is, what I tell my most talented, all the talented lawyers that I know is, do me a favor, please, don't hoard your knowledge. Please do not hoard your knowledge. So I'm asking the lawyers out there to share their knowledge with each other, to form collaborative groups, and that's my bottom line emphasis. Now, how do I do it? Well, what I also try to teach my students is that while we're learning law from top down, legal formalism, there are other jurisprudential models out there in law schools that we could chase, and I do it by way of teaching them the particular cases that we're working on. There's critical legal theory out there. Started in the 1930s with Judge Cardozo. We see McPherson versus Buick, for example, when for the first time a jurist is able to connect the rule of law with what happens on the bottom when the tire exploded, and then we saw this new tort forming. We look at critical race theory, a wonderful theory. We look at legal realism as well, which really many would say is a skeletal framework of what's happening. You look at law. Now, instead of top-down, I'm asking you to look at law bottom-up. Collaboration is the key. It is a key. We can't do it by ourselves. I remember I was talking to a lawyer who helped with the Plyler v. Doe case. Does anybody know what that is? It's a constitutional law case in Texas, correct? First time. Texas opened its doors to educating every student in the state, notwithstanding their undocumented status. And I asked him, what can we do? I was still a baby lawyer. We're on an airplane. There's a dust storm coming. I'm freaking out. How are we going to go up in a dust storm? You got on the plane, it swayed like a boat. Do you know what that feels like? From all the winds blowing on, it's kind of frightening. So to distract myself, I asked this civil rights warhorse, what do we do? And he said, you can't do everything. You have to do something. Just push back. And from that horse, from that conversation in that dust storm on that scary airplane, I decided I was going to approach law from my civil rights background. You can pick anything. Anything. There's so much work to do out there. And there have been successful counteractions out there, counter activities. Requires you to do a lot of digging, though. Now remember, I'm chasing facts and dispelling myths. Some of the successful counteractions that have taken place out there, and there have been a lot, and we have to remind ourselves, because every day we're not seeing it, we're not hearing from it, are the historical voting right battles that we saw in this nation, right? My grandparents, my parents had to fight, right? Grandfather clauses that disallowed them from voting in Texas. My father went to a little school in Texas. His grade school at night had a swing from a tree. I got to see the tree years later. At night, in the evening when the school was closed, the teachers would remove the swing so that the minority children living in that area couldn't use it after school. So they made sure that they were not allowed to share in that. I'm sorry, I have allergies, so my voice is wavering. We saw successful student sit-ins. Students have played a big role in the history of the United States in pushing back. We saw the Black Lives Movement, everybody knows what that is. We saw the growth of ethnic study departments, farm worker boycotts. At one time, we were led to boycott grapes in this country, right, in order to improve the conditions of, farm workers. We have seen repeatedly indigenous land battles. And in the present, a most exciting thing is happening. We're exceeding, a lot of these isolated blips that came up in the past, harmful blips. This is a day before social media. Today, what we're seeing is this organic mass of protests. Colorado had something like 35,000 people protesting what's going on today from top-down leadership. Colorado, Texas is planning a big march, Chicago at the end of the month. But we're not hearing about those protests that are succeeding. It's an exciting, exciting event happening across the United States. These organic mass protests. A lot of them, the energy flowed from the most painful event, the murder of George Floyd in front of all of us. What an awful thing to see. In a city that I happen to like a lot. I went to school in Minnesota. That neighborhood has a unique history. A freeway went right through it, cleaved right through this indigenous community, Black community, disrupted the harm. Disrupted and brought in harm, is what I should say. George Floyd does have, they have a lot of memorial, a big memorial in the corner. Quite interesting to see it, quite powerful. From that heinous event, we saw this energy build up in this country, and it's exploding in the present, and we're not being allowed to look at it. So I'm asking you to please, please dig for those facts that are out there. Dig for that data. You can't, it would be very harmful to you, almost to the point of malpractice, to exclude yourself from the wealth of information that's available to you. But I am promising one thing. It's going to be difficult, challenging. It can be done. It's going to be done. I can't leave, though, with one big reminder. I can't do it. One, I need you to pass the bar exam to the students in the room. I need you to do well, and I need you to go out and kill that bar exam so that you can go on and chase your life. Wherever you end up, I wish you nothing but success. But one tiny big reminder. From the first Trump regime, Trump won, number one. His lawyers forgot to reveal the truth. His lawyers negated the truth, created falsehoods. He surrounded himself with a community of attorneys that rejected learning from bottom up, as we're seeing in anti-DEI, excuse me, principles. And what happened to them? They lost their right to practice law. We have to be careful. We have attorney sanctions to deal with. And if you look up the list of his attorneys that were sanctioned, we're talking criminal sanctions as well, not just civil sanctions. So we have to pay attention to our attorney ethics. Thank you, Professor McGee. And we have to pay attention to the sanctions that are out there revealing, and not only revealing, but chasing the truth. To my law students, I tell them that they are an amazing group of cohorts. I've taught at different law schools. I'm enjoying their high energy levels. They're smart. I always say that students make us smarter as a professor. They make us grow intellectually. My allergies, I'm so sorry. I wish them great success, right? And I also make them a promise that while I am a retired law professor, and while this is in theory my last semester here, I promise them that I'm not going to disappear. And if they need my assistance in anything, they still have my Gmail account. Hopefully they won't forget it, hopefully they'll remember it, and hopefully I'll get some calls in the future. Thank you for listening to me, it's been a pleasure.
All right, I like you can't do everything, but do something. That's good, thank you. Professor Hussey would like to add to this conversation. Professor Hussey, the floor is yours.
Thank you.
Of course.
Thank you, Eli. So I've already made one mistake today. I thought this was an opt-out, not an opt-in for opening remarks, which has left me at the disadvantage of following Dean Conway and Professor Luna, because I certainly would have asked to go first. But I do appreciate, I did learn, Dean Conway, that, and I was going to share, that it is pretty nice when you made everybody move, because not often do people get to boss Dean Cummings around and tell him where to sit. So the next time I speak, I may just tell him to move back over just to watch him do it. As a part of that. That is not above me to do so. But picking up on what both of you had shared, I wanted to start with what may seem a little bit like an uncommon principle here, but I think it falls upon us to do more to speak about the importance and the value of a liberal arts education. So we're here with JDs or students pursuing JDs, certainly with bachelor's degrees. And so I think that education provides us a larger framework for having these conversations. And so there are some benefits and importance, but I don't think those of us here committed to education often spend enough time talking about just how important and how central it is to what we're attempting to do. And when, so a few things to learn from that. So when we talk about, English, literature, psychology, history, philosophy, theology, sociology, anthropology, mathematics, physics even, all of those go to understanding the question of who we are and exploring those big questions from different perspectives. I don't think we do any, I'll leave it to the liberal arts professors, but I don't think it does us any service if we push those things off as the warm fuzzies, and we like to take a poetry class so that we feel good when we're finished with it. The value in the liberal arts education and all of those is that we are exposed to different ways of thinking. We have to reconcile or attempt to reconcile. I mean, I think that's part of the issue here, is that some of that may be irreconcilable at some point, or at least unsatisfactorily reconcilable, about who we are. So it's simply asking, questions like, what does it mean to be human? What makes you human? And drilling down on that through different philosophers, theologians. What does psychology say about that? How have people expressed their struggle defining that in literature that they've written? All provides a framework for us. And the liberal arts offer that critical thinking. They offer that analysis, the structure that goes behind it, dig deeper, and push us to that pursuit of the facts, not being afraid to challenge. We can phrase it as Professor Luna did here, challenging the status quo. But the same thing is digging deeper in all of that, saying, how do we know that? Why do we know that? What else could we know about that? What presumptions have we made to get to that particular point as we rethink that? If we do that in the scientific process, we don't feel bad about it. We expect, even in the liberal arts, we expect people to challenge that, to rethink things, to poke and say, was that person, onto something or not onto something? But I think we need to do that. And I think all of us need to encourage. I mean, we're here at a university. We're connected with the university. Some of us work for a university. I think we need to speak more about that more broadly, because as we'll get into it, it also leads us to, as Dean Conway said, empathy. That was twice written on my first page here. But it leads us to that empathy, to understanding and having that connection with the people that we're going to have these conversations with. If we've never thought about what it means to be a human, or how we define what's essential to that, it's really hard to have this broader conversation. So that is what I would like to offer as opening remarks. So, Eli, all back to you.
All right, so when I was going over and thinking about how this panel would carry on after hearing from the panelists, I couldn't help but notice the very strong focus on education. And it's not lost on me that I'm surrounded by 4 educators, so of course there's going to be a focus on education. But at the same time, I think there's more to it, and any question I ask is to the panel, not to anyone specific. Why is it that when I asked the how and why of difficult conversations, all the presentations go straight to education? I mean, what is the link there? Why is that important?
Good start.
Sure.
So I've spent my professional career in higher education, but also 27 years in the military, and also teaching abroad, and also teaching outside of that context to lawyers. I've been of counsel in a law firm for 15 years. So really, as you are setting it up, it's not education, it's teaching and learning. And we don't necessarily need to pit teaching and learning just in one locus, but it is across the human existence of what we do. And if we think about what we do, teaching and learning in every aspect or phase of our life and life cycle, that's going to give us more of an anchor of the importance and prevalence of teaching and learning writ large, but not just in formal education. And I'm going to stop, but I want to say that if we're going to have this discussion, we need to understand the roots of formal education, particularly in the Western sense, and why that was constructed, and that was constructed for purpose of exclusivity, and understand where education formally came from and what that purpose was, then we need to delve into all of that. But if we think about teaching and learning, these are things we've learned from indigenous communities all over the globe, what teaching and learning means. This is what we have done in our own moral and spiritual lives, teaching and learning in the church, teaching and learning in the what we call the guilds, right? So we have to understand the distinction between teaching and learning and formal education.
And I agree with Dean. There's, in that question, and part of the reason, I opened with, the liberal arts education is there's a difference between transfer of knowledge and the thinking and learning or the critical thinking piece out of that. And I think we started with the what appears to be the education piece, but it is driving toward that deeper thinking and understanding where the conversation, that's a crucial part of what we're trying to do. It's not, information transfer can happen in a lot of different ways, and we can, put labels on that, but it's not where the good stuff is.
So I would not speak for anyone on the panel, but I still get the sense that there is a place, and Professor Luna talked about this, the top-down approach or the formalism, it has a place. It's just not the only place. And we have to look at things from multiple perspectives, and that bottom-up approach is just as important in getting more voices heard. Is that correct? Is that just another facet, or is that the goal?
At the risk of going first again.
No, sure.
You're needed.
And I only do this because most of what I say sparks conversation
That's okay.
as opposed to closing conversation. So I alluded to 27 years in the military. The reason we have, and this chain of command is different from hierarchy. Chain of command is different from formal hierarchy. The reason we have a chain of command is to transparently identify who is accountable, right? Any soldier will tell you, any officer will tell you, it's my troops that got the job done. Any soldier will tell you, any officer will tell you, when something goes wrong, that's my fault. That's why we have a chain of command. That's important, because when you contrast that to a top-down hierarchy for disseminating knowledge through, frankly, what is called, and if you haven't read this book, Paulo Freire, please read Pedagogy of the Oppressed, because that's going to help you understand critical pedagogy. That's going to help you understand how formal education, not just legal education, is constructed. That's going to tell you how these formal education structures were built and why. And Paulo Freire talks about the banking system of education, where we just pour what we think and want our students to know into them, not to see how the blender mixed it up and how the thing comes out differently because of their internalization, the students' internalization of the work, and the intellectualism and learning and knowledge that comes out of that transformation. So again, I think my toss to the panel is we've got to make distinctions about what we mean when we say what is the purpose of formal education.
I understand your query correctly, or maybe I'm going off the rails.
We'll see.
My point is that we have to engage in legal education for a lot of reasons. We're also stymied by legal education. Excluded from formal legal education is a lot of history. a lot of historical amnesia in legal education. There's a lot of exclusionary marginalization by the structure of law, top down. A lot of individuals are excluded, for example, from the right to organize, right, the right to form collective activity. And consequently, how can, I ask my students, engage in transformative events, if that's what you're chasing, if that's the model that you're chasing, how can you possibly engage in any kind of change if you're limited by the language of a little snippet of a case in your textbook? It's not going to happen. You need those basic tools. So for me, education is fundamentally critical, right? Absolutely critical beyond measure. You have to know what the tools are at the starting base. And to complement that wonderful education that we're getting in law schools and institutions is to also excavate that historical amnesia and bring it to the front, because maybe we could learn something from it. That makes sense?
Yeah, I think that makes perfect sense.
I think, separately from your understanding of the query, I want to just talk broadly about this top-down approach outside of classroom. I'll start with, I think that the top-down approach, particularly for first-year students, we're giving you this information, and we have to present it in a way that to give you the top level, because going to law school is very different than being in college. And a lot of students come to that first year expecting to just get the information. You're going to tell me what I need to know, and then I can go and regurgitate it on an exam. So we have this top-down approach in the classroom, but we also have to have that dialogue. And to make this broader to what we're talking about today for both of the panels, we need to be able to have the dialogue with the information from everybody, right? So if I'm giving you the information as a professor and you're not listening to anybody around you, you can't have the dialogue about why this case is important, what comes out of the case, or seeing both sides, to be empathetic to the plaintiff or the defendant, or even to the court about why these decisions are being made. If you're just hearing from me what the case says, what it does, and you're not listening to anyone else, we can't have those engaging conversations, which are also learning conversations, that you're learning from your colleagues in the room because of their different experiences from the liberal arts background. Even if I went to a university, so we had to take some classes in the other schools. So I think all of us probably have some part of a liberal arts background when it comes from college. We have to take English. We have to take communication probably, and good Lord, we had to take math courses or science courses. But I think both of them are necessary. We need to have this top-down approach, even in just conversations with each other. I need to be able to tell you what knowledge I have. You need to be able to share the knowledge you have so that we can have an engaging conversation, as opposed to me just saying, this is what I know, and this is the truth. Mm-hmm. I'm not listening to you. I don't want to hear what you have to say. You're going to hear what my point is, and then we're not having a conversation. Mm-hmm.
Right, and picking up on that, I think that if we're talking about legal education, what we do needs to change and adapt as students go through law school. So I won't put you on the spot and cold call you on here.
Very thankful for that. Thank you.
Eli's in a class with me at the moment.
Agency law. I don't know.
Sure, and this goes to that particular question and case. So because it's not a first year class, there are a number of cases throughout the semester where I put the students in what they find to be an uncomfortable position of imagining the facts that led to the particular dispute. So they're not at issue in the particular case because it's been edited down to the legal facts that are relevant to it. So we have a case early on in the agency stuff where someone falls off a ladder while on a painting project for a church. And at the end of the day, what we're talking about it is an agency law question. Was there authority for this individual to be hired or not? and there was some back and forth. But I use a part of that because there's a little conflicting testimony in trying to understand the people that are involved, the personalities that are involved. When the parish council is meeting in the church basement at 8 o'clock on a Wednesday night, drinking stale coffee on metal folding chairs. That shapes people's, ability to process. But if you understand how some of these things unfold, you end up in a different situation, understanding, the legal point is important. And we run through that doctrine, and there, because the injury ended up being severe. I mean, there was a significant amount of money that was on the line about whether the insurance company was going to end up paying or not. But, a part of, the evolution of that is, drawing students into that. The late Dean Morgello and I used to talk about for a dozen years about making students not practice ready, but client ready, but understanding what the people in the case are bringing as a part of it. But I think that's a transition that can happen in law school. I mean, I'll do that, for second and third year students, because you're at a point where that's going to be more important for you, but it's about building that empathy to understand that these things are not clear cut in their factual development. Your clients are not clear. They're going to come with facts. When we think about this as attorneys, that you're going to have to sort out. And how does that experience, inform you, inform the law, inform advising them, inform the conversations they're going to have about what's fair on the issues that go beyond that.
I didn't expect to stay on education for this long, but it's just too good. And unbeknownst to Professor Luna, I read her article that she submitted to the Charleston Law Review. You did give it to me, not knowing that I would read it in preparation for this. And the very, very brief important facts for what was going on was there were in Arizona there were classes based on Mexican American studies, and there was essentially an attack on getting those classes removed. Arizona obviously borders Mexico, and so they share a lot of everything. I mean, they're right next to each other. And there was something that I thought was really interesting, which was that, and I don't know all the context, maybe this was an honors course, but the students that took the Mexican American Studies classes performed higher on average in their English classes, in their math classes, in their science classes. And this goes a little bit to what Professor Hussey was saying, I think, you can correct me if I'm wrong, but that the arts part and the conversation part, like we were saying, is important. I mean, the Mexican American Studies were important for those students. They performed better in all their avenues. And so I guess my question is, what is it about that broadening, learning the Mexican American Studies, that helped these students? Why is it that a bachelor's in arts makes you just better?
Some of that, so my take on that would be you're learning transferable skills. It's the critical thinking that comes underneath what's there. And so if you're excited to learn something that resonates with you, you'll want to be engaged with that, where the professors, the teachers, or just even the informal teachers come in is guiding you through that process of the learning and thinking so that you can think more critically about what's there. You're not afraid to challenge those assumptions, and knowing that and learning something that you have a passion for allows you to transfer that to other areas as well, because one, it gives confidence that it can be done. And so if there are contrary messages out there that you're inferior, you can't do this, people are pushing you down in broad things, but you know from your own experience that you succeed, that makes a huge difference, I think, when you want to do something new or in an adjacent area.
Else I'd hate to move on if we have more comments.
I think that broadening your horizons gives you more information to pull from. So if you are taking the Mexican American class, you have more information to use in other aspects. The more that you know, the more creative you are about using it in other areas, and you just have more information to deal with and more ways to understand that information and to interpret everything that you're doing. The more you have, the more you know.
And more good information, not
Yeah.
social media and other stuff gives us plenty of information, but
That's
this
true.
is good information.
Yes.
Definitely
We're
questions in
talking
here
about
for
education.
social media. Yep. Professor Luna.
Specific to that experience in Arizona, the students for the first time became aware of the fact that there were brown teachers out there. Prior to that, there were no brown teachers. African American studies came after that, as well in the same institution. There were no black teachers. So for a student to see someone that looks like them, they don't feel so much that they're outsiders now to the educational system. They're no longer marginalized. They're part of that collective effort to learn something. Second, when the state went after them, as we're seeing today, the students saw the wonderful array of books and knowledge that they've been exposed to, people of color, and not just brown people, red people, black people, purple people, everybody. These books were there in that department. They saw law officers go into the school during school time and those books removed from the shelves, as we're seeing today. It was quite a learning experience. And we're seeing that with anti-DEI efforts, correct? We're seeing that in the present. And so in the present, if you're a law firm that is pulling back, didn't Paul Weiss just do that? Big scandal, right? Shocking that a lawyer would retreat in such a way, right? Because of this anti-DEI effort, what message are you giving to the legal community, number one, by pulling back and retrenching? Two, what kind of culture is going to be in that firm? That shows me that a brown person is not welcome. That shows me that black individuals, brown, red, etc. I have to underscore one more thing, that everyone already has DEI programs. When you get hired, it's the learning process, right? Hiring process, number one. Number two, they have programs specific to what? Maternity leave? Is that not DEI? So it's already happening, and it shows the conflicting entanglements that they're pursuing out there and not finalizing by going that route. And again, I apologize for my allergies. They're just so bothersome. Okay, sorry.
So I'll come at it from a different perspective. Johannes Gutenberg invented the printing press in 1448. And that ignited formal education. That also ignited, and I make the distinction, the process of teaching and learning outside of formal education. So these attempts at erasure across these centuries, these attempts at erasure are pitted against that second prong of dissemination of information. And note, in every single one of my comments, I am apolitical. I am not talking about one approach, one policy over another policy. Because what we have in front of us is this perpetual need by those who seek power to tamp down that dissemination of information. This has always been the project. So we have to understand these distinctions between education and teaching and learning so that we can, frankly, preserve both. Ultimately, to, in an iterative process, shake people out of this desire to suppress the dissemination of knowledge.
In efforts to avoid talking about education the whole time, which I'm sure we could, I do have a couple other questions that I think are fruitful. We will see if that's the case. One of which focusing on polarization. Again, as I said at the start, that's something that we might all be feeling more than we have at other points in history or in our lives. And something from the inspiration for this panel was Practical Pluralism from the Obama Foundation. So if you go on Google and Obama Foundation, Practical Pluralism, you'll get their website. And so I looked at some of the workbooks that they have there. And one of the interesting points that was raised was in division and polarization, you get passion. And in passion, you get advocacy for certain issues. And so as far as the why to have these conversations and the how, and of course the what and the other W's as well, is there maybe, and maybe this is the wrong way of thinking about it, but is there a benefit there in polarization that we can extract and leave the polarization behind? Is that a matter of more education, or is that just the way things are? So you look interested, so tackling that.
Well, yes, Eli, I did think about that. Particular question, because so I think to begin to answer that, the initial premise is that passion requires good faith. I know we haven't covered good faith yet in business organizations. I think we start that next week. But I think the passion, and if it's there, it has to be exercised in good faith. And the question is, in the polarized environment, is that the case? I don't know. I mean, I'm curious to hear what other folks think about that. I also question a little bit. I'm not, as to this particular moment in the United States history, I'm not sure that this is the greatest moment of polarization. That doesn't mean, maybe it's in the top 5, I'm not sure, but, or maybe it's not. But I think that this country has had more history of polarization than it has had of unity. So, which is not to say that it shouldn't be addressed and we should sail on past anything that we're in front of, but I think we could find plenty of other examples where people were, it was something in tax policy, I think, where we pulled out some old stuff and the people were as equally animated about how the income tax enactment was going to, it was related to the reporting requirements on the 1099K and some of the things that were filed, which harkened back to employer withholding on W-2 form, that the whole economics of the United States was going to collapse if employers were required to withhold from your paycheck and send you a W-2 so that you could file your taxes. We got over that. But the people that are opposed to the 1099K reporting requirements are resurrecting those same arguments that if they have to report how much they received on Venmo payments for selling things on Etsy, then the economy will collapse and it will be anarchy. So some things always come around. I guess that's my point on that.
Yeah.
So I'm curious what the other folks see about the polarization and on that. But I think drawing passion on those arguments, I question the good faith being there.
Yeah, for sure.
What is good faith? Passion. What's the bad faith?
Well, it's I would say engaging in the discussion for the improvement of the collective good.
That would be the good faith.
Engaging in self-interest only would be bad faith engagement.
So I'll open it up to the rest of the panel, but I'm glad you did say that because that's something.
I will answer it on the exam. So.
Yeah, and I'll try to. Let's hope. Well, I'm marginally younger than the panel here, I will assume. I know that's a brave thing to say. But but I don't care. So when I hear people say that we're in a divided time, I always have, how much of it is recency bias? You know, we're here now, we feel it now, it feels real now, and to your point, it's the ebb and flow of things. And my question is, if we're in a certain ebb or a certain flow, does that necessarily mean we're not still on the right trajectory? And are we even in a divided time, or does it just feel that way? Maybe exacerbated by social media, phones play a huge role, I'm sure, and we're also connected. I don't think any of us struggle to think of a more divided time in the history of this nation. Even, you know, the late 60s and the civil rights movement is not that long ago. And so I'm curious as to the rest of the panel's thoughts. Is it recency bias? Is there more to it? What is it?
No, I think that I think there have always been divided times in the country. I do think that the proliferation of social media, 24-hour news cycles, the way to communicate instantly with hundreds of thousands of people that you don't even know, makes it feel like it's never been like this before. I just think that the media that we have and the ability to communicate makes it seem, for me, unlike any other time that I've been experienced with. But someone who's marginally younger. Marginally younger. I mean, if you grew up with technology and you grew up in a 24-hour news cycle, perhaps you don't think this is any different than any other time that we've been divided. And I do think that the media that we have, the way to communicate, the instantaneous and constant communication makes it feel bigger and harsher than I've experienced in my lifetime.
Sure. Fingers on the trigger.
Sure. I mean, I think even the frequency is one. And again, it's back to asking some of the bigger questions. You know, what is different on the news cycle at this point than different before is that people are expected to have an opinion on a wider variety of matters and be engaged in a lot more than would have been the case 30 or 40 years ago. You know, and a part of, again, this, what we're after needs to be explored in our conversations and our discussions and debated back and forth among ourselves as we sit here and kick around ideas to be informed and reshaped on that. And the current media doesn't really allow for that kind of sustained interaction. And we're in the loop on thousands of things that people expect an opinion on that would not have been the case 40 years ago. It would have been perfectly acceptable to say, I don't know anything about X 40 years ago because I've never run across it in any way, shape, or form. And but I've encountered it now, and I'll learn something about it, which is much different than social media feeds hitting you with all kinds of things and then trying to figure out what the position is and then feeling entrenched in it. That once you've taken a position on something, that you can't change your mind later or move from it. And that cuts against everything that we do in legal education. It cuts against everything you do in theory and undergraduate education, to be always exploring again and saying, what's the best thing that we can be doing? Even if what we liked and what we did before was good, is there a better way to do it? Is there how do we make whatever it is more expansive, more inclusive, so that it's even better than it was 5 years ago, 10 years ago?
I think your question invokes the need to address empathy and positionality. So one person's sense that this is more pressing can be another person's sense that this has been happening throughout my lifetime. So to give you an example, I don't mind saying I'm 57 because I feel like I look okay. I don't mind saying that I'm an older mother because I gave birth to a black son at 43. I have felt this kind of anxiousness, this kind of deleterious lack of humanity my entire life. So if people are just experiencing it now, welcome to that party. But the minute I gave birth at 43, I tell people all the time, I lied to the baby that came out when I said, I will always protect you. That was a bold-faced lie. Because I can't. But what I can do is use the knowledge from the genealogy of black and brown women from which I have come to give that black boy as much knowledge as he could have to survive. If that is the perpetual state that I am in and others have not been in, I glory in your spunk not to be in that position. So for some of us, this is a second by second entrenchment in indignity and lack of humanity and in perpetual fear, right? And yes, I also recognize my positionality of being privileged. I am a dean, but I'm a dean who has to travel. And every single time I leave home, I go, will they be there when I get back? And still have to do this job. So no, I think that many of us have been dealing in this situation, and some want to call it kleptocracy, others want to call it authoritarianism, others want to call it fascism. But there is a certain identity of person who has been dealing with this since the minute our ancestors got here. And that, unlike generational wealth, has been passed on.
I'm curious, Dean Conway, if you have any thoughts on the role that social media plays and our phones and the interconnectivity, and maybe where my position originally was more negative, maybe it's part of that, maybe part of the positive is the awareness aspect.
So I do think that connectedness, and that's why I'm not going to use social media, I'm not going to use it's connectedness. There has been, and I've studied internet law and policy because I taught the class. I've done a lot of things. I've had to do a lot of things. That's what this positionality required. But I think what the internet and the Internet of Things and the Internet 2.0 and then social media, what that has done has initially built on a platform of connectivity, which is a good thing. And we've been doing this for all of human existence. So in that way, I don't see social media as in any way, extraordinary or, sort of like the thing that has transformed us. It is just another level of connectivity. But what we must do with that thing, and this is where the issues really are, what must we do with those tools? What must we progress with using those tools? We don't have the fortitude to figure that out. Because, as my colleague here, Professor Luna, has identified, there is a status quo that benefits those who are in power. And if we all, in our positionality, in our identity markers, can't understand that, we will be yoked to this positioning until the next generation. This is the work. Is how to use these tools for collectivism, for coalition building, to take the Derek Bell lessons of the perpetual nature of this oppression and say, we are going to transform this to a perpetual nature of dignity. This is what we need to be doing, and we can use these tools to do that.
So sticking Dean Conway, we're having a bit of a conversation right now, but it's clear that empathy, I think, is at the center and at the front and is essential in all ways. And I guess my question is, that is the what's needed, but I guess where's the gap? Or rather, no one thinks, I'm not very empathetic. And so for everyone, what is that step to get there?
So as I have, and this is the first foray into what anti-racism and institutional anti-racism means to me and how I've defined it in my scholarship, simply it means acknowledging our historicity, which brings in that empathy, and that's different from history. Historicity is the facts and the people and the events that they went through. Yeah, that's a different level than history, telling a story, particularly telling his story. You know, historicity calls us to be more engaged with the day-to-day of the people and the times and the events. And then the second element of anti-racism is to teach and learn. So that means sometimes death scrolling, but really to teach and learn, like pick up a book, literally, and teach yourself something. Like I said, look, I could give y'all a test here. I've put out a number of authors and a number of book titles in this talk, and I do that intentionally, right? And I could ask you, hey, what did I say? And only half of you would be able to respond to me on that second element of teaching and learning. And teaching and learning doesn't mean just reading one category of books, right? People are shocked when they come in my office and I've got Ayn Rand there, right? Look, I did it again. I gave you another one. They're shocked. I'm like, no, the teaching and learning is the part of anti-racism, right? I also have Hannah Arendt, okay? So I'm good. But then the third element is to take action. That's the third element, right? You talked about that, Professor Luna. Take action on what you have learned and what you were capable of acknowledging.
Okay, can I talk?
Yeah, please.
Can I add something?
Yeah.
I just want to add that history is not left to dusty books, for example. History requires engagement. Sometimes you have to wear a mask because there's a lot of dust in those books, in the archives. You have to go to different places beyond the law library. But history is also alive in the present, extends into the present in the sense that I've had calls from, for example, I've done a lot of work on land grant, people that lost their land, indigenous in 1800s, 1900s, and then into the present, their descendants are still fighting to recover those lands, to recover recognition. And they're engaging in litigation in the present, and they need that new scholarship that's coming out because it connects a lot of missing positions throughout there and legal gaps that weren't allowed in case law or the way we've talked about it in those ancient cases. It's just ugly language that's used, calling brown people idiots and ignorant, and a lot of that is used in litigation that I'm seeing in Texas, for example. Every once in a while, I'll get a call, and it's interesting, from people that are daring to pursue, right, not only their truth, but daring to challenge why their families lost land. The majority narrative, the main narrative, the dominant narrative in law is that they lost their lands because they were ignorant. But if you dig more, you see that law was used as a weapon against them. And you can show them procedurally, the civil procedure of a case, and show them through my excavation of primary cases when I went digging throughout the United States, chasing deeds in different archives, a few documents that remained after Captain John Fremont raided the house where all the documents were kept. Captain John Fremont, right? Does anybody know who he is? The spy catcher, went spying for the United States before they took the land from the indigenous, grabbed the deeds and went up to the mountains to meditate, and he accidentally on purpose lost them. So how do you prove that you own land if your primary documents are missing? But yet at the same time, they were being told they were ignorant. So that history that I was able to excavate by looking at the original documents, the language that was used back in the time, it's being used by groups in Texas, California. It's wild how they go back and they call you and ask for help. And I love it. I just do. So it's still around. That's my little world. So I still get phone calls. It serves a purpose in the present. It's an engagement, an interaction. You have this relationship that can be of use for others, because I can't bring those lawsuits. And it's a collective effort. And I'm just one tiny little prong in that big picture. Thank you.
Yeah, thank you.
So, Eli, I want to add one. I know you probably want
No.
a question here, and we haven't talked much about what and how yet. So, but you had mentioned at the beginning of the sequence that you were not very empathetic, and it occurred to me that I didn't offer a definition of empathy. I work from a definition of empathy that is understanding as best I can where the other person is coming from. That is, and sympathy is that same feeling. So I don't have to agree with someone's position. I don't have to feel the same thing that they do in order to have empathy. So empathy is understanding that person, valuing that person as a person, what they're saying, as them sharing their experience with me, even if, my analysis of that might be different, but I hear them, I listen to them so that I understand them and communicate to them that is an important perspective to bring, that I value that it makes, me richer to have more of these perspectives around me. But that, I don't have to be them to accept them. I guess that's where
Sure. Yeah.
So.
I couldn't just put Professor Luna on the spot, so I did read your piece that you sent to me, Dean Conway, and there was a term in there that I had never seen, and it, I think, is coming from the definition of empathy that Professor Hussey just gave us, and I might not even be pronouncing it right, but praxis-informed anti-racism. And you said it's important, and this really goes to the how of this conversation, these difficult conversations, to start at different levels of comfort. And so when someone's maybe not as comfortable, that's a completely different scenario than when someone's more on board. And I was curious as to why that's such an important part and maybe what it looks like.
Sure. And let me say, too, I wanted to stay for the second panel, and I apologize to those panelists, but I have to be in Washington, D.C. So when I was asked to do this, I squeezed this in and pushed a meeting in Washington, D.C. back because I thought the effort and the title was fantastic, and I felt like I had to be here. So let me say that, and I hope you are taping this so that I can then view the second panel. And maybe we can come back and have an additional conversation. But yeah, praxis informed. What that means is, first and foremost, to help describe empathy, it means taking what you know, sometimes what we know is doctrine, taking what we know, sometimes what we know is practice. Taking what is epistemological, sometimes what we know is based on what we have experienced and what we feel and what our path has been. So taking all that and then saying, I know those things about myself. So if I know those things about myself, radically assuming that this is the same for others. Right? So do not question the epistemology. Do not question the doctrine. Do not question the wisdom and the experience of others. And engage with that. And in that, it is getting at that good faith, right? And it does not say I can't do all those things just because somebody holds power. It's doing it in spite of the fact that others may hold power. Right? So this means that you are engaging and intellectualizing the experiences and the doctrine and the epistemological existence of another. And where did I learn this? 14 years at the University of Hawaii, William S. Richardson School of Law, where I came of age in a host culture of Native Hawaiians, indigenous peoples. So to be able to be in that place and space using the pluralism, this is why this whole thing spoke to me, the pluralism of an indigenous way of being, which was right next to and sometimes overlaid by the Western legal tradition, help me see how these things connect, but also how they diverge. And then examining what were the reasons those things diverged. You know, in some sense, capitalism was the reason where this Native Hawaiian host nation was more communal. But that does not mean, and I am not romanticizing indigeneity because I lived in it for 15 years. That does not mean that there were not challenges there too. But what this radical, practical praxis pluralism is all about is opening your eyes, acknowledging the historicity, teaching and learning about it, and then taking action. So this 15 years helped me come up with this thing I'm calling institutional anti-racism, which is not to be conflated with diversity, equity, inclusion, and belonging, which is not to be conflated with affirmative action, which is not to be conflated with any other anti-Blackism that is out there. It stands on its own and it is informed by this pluralism. The best of things in a capitalist market, the best of things in an indigenous host nation, the best of things in my travels throughout the Asia Pacific region, which was my teacher as I was its learner. This is where it comes from. And that's the genesis of the praxis-informed pluralism. You know, we law teachers, we got to do stuff like that.
So I do have a question. Most of them have been pretty general, but for Professor Miss-Kye, who is our faculty director for the Center for Equity and Justice. And I was curious when I was writing questions as the faculty director, what is it that equity means to you and what role does it play in what we do as the center and having these difficult conversations?
Well, of course, equity means that we are all on, or can at least try to get to the same plane. You know, you've probably seen that cartoon where the kid is standing trying to look over the fence, and Equal would have both persons standing on the same level of a block trying to look over, but Equity is bringing more blocks to the shorter person so that both people can look over. I'm not explaining that completely, but
I know exactly
you
what
know
you're
exactly
talking.
what I'm
I've seen it a
talking
million
about.
times.
So it's so that we're on the same plane, and that doesn't mean that we are all the same, but we are on the same plane and have the same opportunities to do what we want to do as well as everyone else. And so the center is working towards that. We are working towards getting all persons who want to go to law school through the LSAT pathway program, that we're trying to make sure that everyone has an opportunity to learn how to ace the test, regardless of race, regardless of even wealth. But we are looking to get people who don't have the higher boxes, right? If you put everybody on the same box, the people that might need a little more of a step up to get to the same place, that's equity. When Gabe talked about the policing program that we have with Walmart, is it fair? Is it equitable to prosecute someone who's stealing electronics out of Walmart the same way you prosecute the person who needs diapers? No. Equity there would, let's prosecute with the empathy for why they are stealing, and then prosecute the person who's stealing the electronics with the same empathy. Why are you stealing this? Well, I'm trying to go and get more money and do these things, as opposed to I need diapers, I need food, I need socks. Different crimes, but can we have an equitable way to prosecute those things? People who can't afford an LSAT prep course, and it's intense. I mean, these students are coming in twice a week for 2 hours a day for 12 weeks to learn how to ace the LSAT for free. Some people can afford to pay for an LSAT prep course. Is that equity? Is equal is not saying, well, you need to pay for this course, but equity gets them to the same place to compete for a slot in a law school, because they all want to go to law school, whether I can pay thousands of dollars for the LSAT course, or if I can take this grant and be committed to doing the work for 4 hours a week. I'm working full-time, some of them, I am in school. Can I commit to it so that I can have this free program to help me compete with someone who can? That's equity to me.
Yeah. I just want to point out, with the program, we've already had students from last semester already applying to schools, applying to this law school, and it's rewarding to see the quick turnaround.
And have been admitted.
I didn't know if I was at liberty to say, but we are apparently. So lunch is fast approaching. We have 1 minute, and I never want to be in between people and food, but if there are any closing remarks that anyone would like to make, no one has to. That's fair, because it is lunchtime. So thank you for being here and enjoying this panel with me. Let's go ahead and get some lunch right outside there. Thank you.
Now? Okay. Okay, good afternoon, everyone. I'm going to adjust this because I'm a little bit taller. Welcome to the 18th Annual Dean's Diversity Forum. We just completed panel 1, which was how to practice practical pluralism. And so we are going to start panel 2, which will be on the topic of modeling difficult conversations, equitable inclusion, which is going to be on the topic of DEI and what DEI is and how current legislation and law on DEI practices is impacting our communities on a local and on a national scale. So with that said, we do have one speaker who will be arriving in a few minutes. So I'm going to go ahead and get started with speaker bios. I'd like to say that all 4 speakers are incredibly accomplished people. So what I'm going to read is not going to completely capture all that they've done. So keep that in mind. And then I'll pass it over to our speakers to introduce themselves briefly, and then also give their initial thoughts on what they think DEI is and how it's being impacted in our country today. So with that being said, I'll start with introducing our Dean of the Law School, Dean Andre Douglas Pond Cummings. He is the Dean and Professor of Law at Widener University Commonwealth Law School. Dean Cummings was formerly Associate Dean of the University of Arkansas at Little Rock William H. Bowen School of Law. Prior to Bowen School of Law, Dean Cummings was a professor of law at West Virginia University's College of Law, and he has been a visiting professor at numerous law schools. Prior to his academic career, Dean Cummings clerked for multiple circuit judges and represented clients in the sports and entertainment industries. Dean Cummings has been recognized as Professor of the Year on numerous occasions. He has recently received 3 Faculty Excellence Awards at the William H. Bowen School of Law, including in social justice, research and scholarship, and public service. Next up, we have Professor Domino. I just have to say, I have a class with Professor Domino right now. It's in evidence, and he's absolutely fantastic. I'm learning a lot. But Professor Domino teaches courses related to constitutional law, election law, federal courts, statutory interpretation, and criminal law. He has written extensively on constitutional law, free speech, and election law. He's a 2-time recipient of Widener Douglas E. Ray Award for Faculty Scholarship, a 2-time recipient of Widener's Outstanding Professor Award, an elected member of the American Law Institute, and a Fulbright Scholar. Next, I'd like to introduce Dean Todd Clark. Dean Todd Clark is the Dean and a Professor of Law at Widener University Law School. He's an avid scholar and writes on legal issues involving employment discrimination, sports, and the intersection of hip-hop and culture and the law, as well as corporate justice. His work has been published by Oxford University Press and Carolina Academic Press. Dean Clark has also co-authored a textbook with Dean Cummings entitled Corporate Justice that explores issues of social justice, corporate power, and diversity. Prior to joining Delaware Law School, Dean Clark was the Senior Associate Dean of Academic Affairs and a Professor of Law at the St. Thomas University Benjamin L. Crump College of Law. Lastly, I'll briefly introduce Mr. Zimmelong. He'll be here in a few minutes, but just so that you all can get a little context on who he is, he's a veteran trial lawyer with extensive experience, having acted as lead counsel in over 500 cases across federal and state courts. He has also acted as lead counsel in private arbitration and before government administrative law judges. He has tried numerous cases to verdict, maintaining an undefeated jury trial record. In 2022, he secured one of the top 100 verdicts in the Commonwealth of Pennsylvania. A staunch believer in the Constitution and the free enterprise system, Mr. Zimmelong regularly represents Republican, federal, and state elected officials and candidates, the Republican National Committee, and the National Republican Senatorial Committee, and the Republican and conservative PACs and nonprofits. So with that said, that's some context on all of our speakers today. I'm going to go ahead and pass it along to Dean Cummings to give a brief introduction as to who he is and what he does and what his thoughts on DEI are and what he thinks it is.
Good afternoon, everyone. Thank you, Tara, for that introduction. I did not get a chance to introduce Tara, so I'll take a minute to do that, as I did with Eli earlier today. Tara is a center fellow. She works for the Center for Equity and Justice. Once we formed that center and received funding, she was the very first person that we hired to help us lead the center. Tara is outstanding as a center fellow and has done such superlative work that I've now hired her to do 2 other jobs for the dean, which I hope she can still graduate with all of the work that she does for me. But she is my development liaison, sets up all kinds of meetings and schedules with alumni for me, schedules meetings with alums, and we just received a $110,000 grant from the Law School Admissions Council to do LSAT training for the summer, for the Guided Journey Plus program, and Tara is now the program director of that summer program. So she'll be coordinating 850 scholars and about 10 instructors in that program. So Tara is fantastic, and we're very grateful that she's moderating for us today. So when we had the idea for the 18th Annual Dean's Diversity Forum, the thinking was we wanted to have a panel about why to have hard conversations civilly, and then our job for Professor Domino, Mr. Zimmelong, Dean Clark, and myself is to now model that civil conversation. So we're going to talk about an explosive issue that's maybe explosive, I don't know, controversial issue currently. And we're going to talk civilly about it, and we're probably going to have very different opinions about the value on a going forward basis. But I always like to begin conversations about diversity, equity, inclusion, belonging by talking why we historically need to think about equal opportunity, diversity, equity, and inclusion, which is that our country has struggled for centuries, almost a decade, centuries, with the race question in this country. We were a country that was founded on slavery. We had a very difficult time ending slavery. It took a civil war to do that. Equal opportunity after slavery was ended was very difficult. We had a Jim Crow era. There were horrible history of lynchings, and I'm just talking about the African American population in this country, not yet speaking about our very difficult interfacings with Latin Americans and with our neighbors to the south, as well as Japanese internment camps, Chinese restrictions. We've really struggled in the United States with the question of race. And so I always like to ground these conversations in that, because I often think when we're talking about affirmative action, when we're talking about DEI and inclusion and those things, we need to understand why we're having the conversation, why it's needed, why there is why there seemed to be a point in time in the country where we really needed to try to equalize playing fields and provide equal opportunity for everybody. And so often in these conversations, I really like to think about the fact that in 2025, it's good to ask ourselves, have we arrived at the place where it's an equal playing field, where there's equal opportunity for everybody? And in connection with our pathway programming that we've talked about today, our LSAT training for first-generation students and marginalized communities, I think some people would argue that we haven't arrived, that we still have work to do, that there needs to be, we need to really look hard at impoverished communities and underprivileged backgrounds to make a determination as to whether everyone's getting their shot at the American dream. And so for me, diversity, equity, inclusion, belonging really is about playing fields, making sure they're leveled, opportunities for everybody, and providing what I would assess as the removal of obstacles that have been established historically against certain populations. And so for me, the fact that DEI has become a very difficult buzzword of late is missing the point of removing obstacles, making sure that everyone has the opportunity to achieve what they hope and want to. So the last point I'll make is that for me, every time I travel abroad, I love coming home. I really enjoy Brazil, very much enjoy Japan, enjoyed Spain and France the last times I visited. But this is where I want to be. This is where I love living. I love the opportunities here. I love the American dream. I love the freedoms that are available. I just want to make sure that everyone gets them, that everyone has an opportunity to grasp what they want. My life has been blessed, and I have had the opportunity to go after and become exactly what I've hoped and wanted to. And it's important to me that everyone has that opportunity to pursue and achieve what they hope and dream to. And we are a fabulous country that in my view still needs to get the race question right, and that still needs to figure out a way that we don't lead, or that we don't have the kinds of poverty and disadvantages that are still present. So that's what I would where I would like to start. Thank you, Mike.
Thanks, Dean. Thanks, Tara. It's always nice to have nice things said about one, even if they're coming from one who's hoping for a good grade at the end of the semester. One of the things that makes it difficult to talk about DEI is that it means so many different things to different people, has been used in different ways, and even the terms within the term are mean different things, and those differences often aren't focused on. So I wanted to start just with that, and the degree to which I take issue with the DEI enterprise. The inclusion part, I don't find troublesome at all, at least in theory. I have no quarrel at all with the goal of making everyone who's in an organization feel included in the organization. Or if you want to add belonging, which I don't consider to be different from inclusion, but making everybody who's a member of the organization feel like he belongs in the organization. I think that's perfectly appropriate, beneficial, moral. It doesn't seem to me to be at all controversial. Equity, I have more of a problem with, but again, less in theory. Equity as a concept I think of as nearly vacuous, that equity just means fairness, and as everybody who's gone through law school knows, fairness means nothing. It means different things to different people, and so it doesn't provide any kind of basis on which to decide this given program is equitable or isn't. Instead, you're just giving power to somebody or some organization to impose something on the basis that that person has judged a certain result to be equitable, and I don't like that kind of process, and more on that later. The diversity aspect of it, again, in theory, I support. I like the idea of certain institutions, especially law schools among them, representing a diversity of viewpoints. I think that in a panel like this, it's beneficial to get a diversity of views out, and if a forum was less an exchange of views than just a presentation about one point of view, then it wouldn't serve the purpose. So again, in theory, I support that kind of effort. In practice, however, I think as most of us have experienced, that's not what happens. That DEI in practice has amounted to racial balancing, lowering of standards, worse results. People are hired, people are admitted to school, people are retained in jobs that they wouldn't have were it not for their race or other demographic characteristics. And as a result, the performance of the organization is harmed. It just stands to reason that if the determination of whom to admit, whom to hire, et cetera, is made on some basis other than excellence, then you're going to get less excellence. In addition to that, that kind of racial preferences are tremendously unfair to the people who don't fit into the preferred demographic category. People who were born into certain races are favored. People who are born into certain races are not favored. Same thing with other kinds of categories, and I think that it's tremendously unfair to give someone a leg up because of those kinds of characteristics. I'm proud to be here today talking against racial discrimination. And if you do think that it's appropriate to play racial favorites that way, because you think, well, the society's playing field isn't level, or somebody's going to have the power to determine what a level playing field means. Who's going to get the benefits, how much benefits, for how long the benefits are going to persist. And really what you come up with is the people who get the jobs, the people who get the money, the people who get admitted to school are going to be admitted based on political calculations. Do you meet the ideological or political agenda of whoever has the power to make these kinds of decisions instead of your demonstration of excellence? I don't want to run over time, but I think I have a few more minutes to talk about a couple of things. Diversity in particular. The reason that we talk, at least I think this is true, the reason that we talk about diversity in those terms is because Justice Powell in the Bakke case told us that that was the way to get racial preferences through constitutional review. And what the court said, starting in Bakke and continuing through the 2003 Michigan cases through the present, is that racial preferences for the purpose of making up for past discrimination is unconstitutional. That is, equalizing the playing field. Racial preferences to make up for society's racial discrimination in the past is unconstitutional. What the court had said was constitutional was using racial preferences to produce a diversity of views. So we talk about diversity of views. But the schools that imposed racial preferences are not especially likely, in my own experience, to want a diversity of views. Mm-hmm. Perfectly fine with having faculties that are 95-5 in favor of liberal democratic positions. The idea that the views of a law faculty or a law administration or the legal academy generally, or the academy generally, would be representative of the views of American society, I think it's self-evident that that's not what's actually being pursued. So while I am sympathetic to the idea that Congress can impose certain measures to remedy past discrimination, the 14th Amendment, after all, says that Congress has the power to enforce the guarantee of equal protection, that isn't the rationale on which DEI programs have been advanced. And the idea that the racial preference programs that have been used in places like the University of Michigan, in Grutter versus Bollinger or Gratz versus Bollinger, are narrowly tailored ways of achieving a compelling interest is frankly laughable. Even if you think that diversity or the educational benefits that flow from diversity is a compelling interest, and I think that's a stretch given that probably isn't a compelling interest to have a state-supported law school in a state at all. But even if you grant that, the idea that the racial preferences that were being imposed were narrowly tailored to that end is not at all realistic, and becoming less realistic all the time as the increase in the number of interracial people and households grows. If you wanted to engage in racial balancing, I frankly don't know how you'd do it in an accurate way now, given how diverse the racial mix of the population is. So I think I will stop there. I appreciate you all being here, and I appreciate the opportunity to share my views on this panel. Thank you.
Thank you so much. I'm really excited to be here at Commonwealth. I always enjoy my time coming up here to visit the faculty, staff, and especially the students here at our sister law school. And I also am happy to share this conversation with my mentor and one of my best friends in the entire world, Dean Cummings, and then Professor Davino, and then our also fellow guests. I've heard really great things about both of you, and so I'm happy about this conversation. I do want to, start to sort of frame this conversation, because I think that there's a piece that has been missing from this discussion, because we've talked a lot about DEI and race, but what we haven't mentioned was the fact that DEI has also been important for helping to ensure that women also have access and opportunities. And I think oftentimes that gets missed. I mean, if you think about women's rights in America and how difficult they have been, DEI has gone a long way at giving women an opportunity and a place at the table. So I think it's important to sort of add that piece to it. From my perspective, DEI is about merit. I think one of the things that all of us can agree with at this table, we want to see people that get into law schools, people that get opportunities. We want to see the best candidate get that opportunity. From my understanding and my vantage point and my experience with DEI, DEI has helped us accomplish merit because it puts all of the people in the room and lets them fight to determine who was the best person. And so I want to give you a sort of example. One of the things that Professor Domino mentioned, and I thought this was a really interesting point. He says what has happened in practice is that DEI has resulted in less excellence, and that occurs when you provide these racial preferences and allow people opportunities just because of this color of their skin, and adding women to this equation because of their gender. So I thought back to this really momentous occasion in the history of America, and I went back to the United States Constitution and when it was written, and that was in 1787. Now, just out of curiosity, how many black men were in that room when the Constitution was written? Anybody help me with this? Okay, all right. Okay, what about this? How many women were in that room when the Constitution was written? Okay, let me try one more. How many Hispanics were in that room when the Constitution was written? 0, right? So it sounds like a bit of a rhetorical question, but if the conversation is about that preferences create less excellence, there was a preference at that time, and who was that preference for in that room to write the United States Constitution? It was a preference for who? White men, right? So if that's the case, right, then that means that the fabric of our institution, the way that it was created, this document that governs our lives, was based on less excellence. And if that's the case, maybe we should scrap that document, because again, this would flow naturally from this conversation that is advanced by most conservatives. Let's scrap that document, and let's scrap all of the references to the framers, because again, that would have been created with less excellence. So sometimes for me, if you really want to take this conclusion or this analysis to its natural conclusion, that would be the conclusion that that group of individuals that created that document was done with less excellence, and we should be very concerned about letting that frame our future and frame the way that we think about the world. I'm not so sure that that's the direction that people want to go, but I do think we need to be mindful and be very careful about how we frame things. The other thing that I often hear is this idea that it results in less excellence, and somehow that we get into these results where people get things that they shouldn't receive, and that the organization is somehow hurt. I actually haven't never seen evidence of that. Like, I'm always curious. I hear this statement, and I wanted to just kind of highlight something. There's an area that Dean Cummings and I spent a lot of time writing about, and it was something we were really passionate about, probably about 15, 20 years ago. We did a lot of stuff in sports law. And Dean Cummings and I had an opportunity I wish Johnny Cochran, that was my mentor growing up. I didn't get a chance to meet him, but we did get a chance to meet an amazing attorney named Cyrus Mary. And some of you may know that Johnny Cochran and Cyrus Mary got together and they helped in working with Mr. Rooney, created the Rooney Rule, which requires that all NFL franchises interview at least one minority candidate before making their final hiring decision. And part of that analysis came from some analytics that Cyrus Mary and Johnny Cochran hired Dr. Madden, who was from the University of Pennsylvania, to conduct some analysis on the success of black coaches. And this is what they found. Black coaches average 1.1 more wins per season than white coaches, 9.1 versus 8. Black coaches led teams to playoffs 67% of the time compared to 39% of the time for white coaches. Black coaches average 2.7 more wins in their first season than white coaches, 9.5 to 6.8. Black coaches average 1.3 more wins in their final season coaching than teams with the white coach. Black coaches inherited teams averaging 7.4 wins per season and increased the average to 9.1. The average dropped to 8.9 wins after a white coach took over. And then finally, 66% of teams led by a first-year black coach made the playoffs compared to 20% of teams coached by white coaches. To me, that doesn't sound like an example where promoting diversity actually resulted in a reduction in outcomes. It actually sounds like it improved outcomes. And again, the Rooney Rule, like many diversity initiatives, doesn't require that the minority candidate gets hired. It just provides them an opportunity to get in the room because there was so much exclusion happening. Well, they don't have the experience. And they couldn't get the experience because they couldn't get the jobs. So it perpetuated this vicious cycle. Diversity opened the door so that we could compete. That's why it's so important, and I think that's why it's really valuable. I want to be quiet now and pass it on to my buddy to the right here.
Well, thank you, Dean Cummings, Dean Clark, Professor Dominio. Always good to see you. And thank you, everyone at Widener Commonwealth for inviting me. It's an honor to be here. I do apologize for being a few minutes late. My name is Wally Zimmelong, and what was interesting is when I was walking in, I wasn't able to hear Dean Cummings' comments, but I started to hear at least a majority of Professor Dominio's comments. And by way of background, Professor Dominio and I, we have briefed and argued a case before the Pennsylvania Supreme Court. And we've worked and collaborated together on a number of amicus briefs, and we had not talked, I can promise you, before I came here today. But as I heard his remarks mirrored, maybe not surprisingly, so much of what my perspective is on DEI. So I apologize if I go over some of the same ground, but I do have some. Maybe some nuanced differences that I'd like to highlight on it. And I'll start by saying that when we talk about DEI, we really need to compartmentalize diversity, equity, and inclusion because they mean very different things. And I agree with Professor Dominio that probably the less insidious of the three is diversity. And I think diversity, most people agree, diversity as an end in and of itself is a laudable and noble goal. I think where we run into problems is the means that we achieve the ends. How do we achieve diversity? I think we also are going to find disagreement on what diversity are we talking about. Are we talking about diversity based upon immutable characteristics like skin color, like gender, like ethnicity? Or are we talking about diversity of thought? And I think if we're talking about or diversity of socioeconomic backgrounds, I think diversity of thought and diversity of socioeconomic backgrounds, I think if we're focusing on that, I think we're probably going to find a lot of common ground. And I also think that we're all going to reach the same ends. I think if we look for a diverse socioeconomic background, a byproduct of that is going to be diverse, a diverse student body or organizational structure from an immutable characteristic backgrounds as well. I also think diversity of thought is far more important than diversity of characteristics, especially in higher education. and especially at a place like a law school that depends on critical analysis and debate. And unfortunately, I think, and especially in some of this has been rather ugly in the way it's manifested itself. In recent years, we've seen what organizations look like when there's a lack of diversity of thought, particularly in higher education, particularly over the last 12 to 18 months. So I think first we need to sort of focus in on the diversity aspect of it. What are we talking about when we talk about diversity? And then we can talk about how we get there. Diversity that, for diversity's sake, where we say, well, we want diversity that reflects, different races, different ethnicities, and different genders. For that purpose, I think is problematic because it's unconstitutional and illegal under many federal statutes. It's also immoral because it suggests that those having the characteristics that need to be imported into an organization lack the inherent ability to achieve acceptance into the organization by itself. And this is something that we heard, and we've heard since Clarence Thomas became a Supreme Court justice. He has always been an ardent opponent of racial classifications and quotas because he wanted the world to view him on merit. I haven't heard. I don't know that I agree, or I don't know that I would consider the diversity diluting the excellence of an organization. Although I think that if the ends that are utilized to achieve diversity are such that we're just plucking people out because they check the box on an application, or because we want a certain number of Black students, a certain number of Asian students, and a certain number of white students or Latino students, naturally it's logical that the excellence of the organization will suffer because those factors are being placed ahead of objective factors that would manifest themselves in ultimately in the excellence of the organization. And I think by excellence we mean the achievement of the organization. So I think we have some discussion that needs to be had around that as well. Dean Clark's analogy of the founders being not diverse, and therefore the logical conclusion of that is that organization, our constitutional Congress, lacked excellence, I think is misplaced, because I think we need to understand, and I think it's rather an uncomfortable understanding or an unfortunate understanding, is that those that were the only qualified individuals to be at the Constitution Convention at the time were white men. I'm sorry to say it. It's just that's what the situation was in 1787, was that those that had the education and the ability to attend were white men, and women and blacks and other minorities just didn't have those qualifications at the time. I don't know that we're in the same environment today. There are Black women, there are Black men, there are Latino women, Latino men that are, from a qualification and merit perspective, equally, if not more qualified than white men. I've had my butt kicked by Black women in court just as much as I've had my butt kicked by white men, and I've had Black male judges and Latino male judges smack me around just as much as white men. So I wanted to point out that distinction and perhaps maybe fundamental flaw in the underlying thesis there. I think where we run into some more issues and is on the equity end. I think if we're on the sliding scale, inclusion, I'm not really sure what that means, but equity is much more problematic. Because equity of the law is something that you're compelled to do. Equity, as is often said, does not mean equality. And when we seek equitable relief in the court, we're asking the judge in the court to use its powers to make somebody do something they ordinarily wouldn't want to do, or prevent somebody from doing something that they want to do. So there's a thumb on the scale of the outcome. There's a compelled outcome there. And when we talk about equity in higher education, and we talk about equity in society, and we talk about equity in any organization, then we're talking about really just inserting somebody in there for the sake of it, and not really caring about why it's being done or what the basis is of it. Equity is itself a means to an end. And I think that's very problematic, very problematic. I also would add, from personal experience, by way of background, I do quite a bit of public policy and constitutional litigation, and I've been fortunate enough to litigate race-based, DEI-based programs. In fact, I have a matter now involving, I get what you would call a DEI program involving the School District of Philadelphia, and the way they assign students to their special admit high schools, which the plaintiffs believe was an illegal race-based, unconstitutional race-based set-aside. And we're in the Third Circuit now on that issue, but we had the opportunity to take discovery, and one of the people I took discovery of was the Chief Diversity, Equity, and Inclusion Officer of the City of Philadelphia School District. And some of the things that she said that underlied what their DEI program was were quite remarkable. There was a hostility to a merit-based system, that merit-based systems are in itself oppressive, and that we should not engage in any sort of merit-based any merit-based selection in and of itself was problematic because it resulted in inequitable outcomes. She testified that colorblindness is very problematic because it erases the race or ethnicity of the person that you are attempting to be colorblind to. So stuff like that, as it flows from DEI, I find frightening, frankly, and problematic, and unconstitutional, of course. But these are the things that we need to talk about and we need to discuss, and I look forward to discussion and questions. And again, thank you for having me.
I'm not even sure we need a lot of questions, because I think there's probably a number of things that each of us wants to respond to.
Thank you all for sharing your initial insights on the topic. It's great to have all these brilliant minds. Just so much information on. I know that I personally really enjoy dissecting a topic. I like to hear both sides of all perspectives on a matter, because even though I may be set in my ways and my perspectives, I always find that I learn from another person who may be viewing things from another perspective. So I'm really excited about this conversation. I'm so happy you are all here. And so before I start with questions, I just want to let everyone in the audience know you should have a blue or a yellow flashcard by you. I want you to engage with this conversation, and as questions come up throughout the panel, please feel free to just write a question on that flashcard, and then you could pass it to my co-fellow Eli over there, and we'll make sure that they get asked. So with that, let's continue with this conversation. So my first question for you, and I think we've kind of got into what DEI is, and it sounds like equity is a big term that is kind of vague, and we can pull apart a little bit more. So with that, I want to say that DEI has become a broad and contested term. And from your perspectives, what does DEI mean in a legal or institutional context, and where do you think there's agreement or confusion about it?
I'm gonna start by asking, has anyone heard anything that has made them feel uncomfortable so far? So what are the things to me so important about what we're doing today? We need to have uncomfortable conversations. We need to be able to have them and talk about them, and that's what I think a law school is for, is to have uncomfortable conversations. And I have heard some things I'm diametrically opposed to, but it is our goal today to have an agreeable disagreement and have an uncomfortable conversation about something that is really critically important, I think, to the fabric of the country. And so I would start by saying that I often hear talk about merit, and I often hear talk of excellence, and I always wonder, like, who's, and I think Professor Domino even said this, like, who's deciding what a level playing field looks like, but who's deciding what merit and excellence is? And if merit and excellence goes to standardized tests, then I'm here to tell you that they're not fair. That standardized tests, if we're talking about that, we do an LSAT pathway program. And in our LSAT pathway program, it's open to everybody. We have people from all stripes that take this pathway program, but we'll read a passage in the LSAT, and I will ask the students, do you all know what this term means? And there will be students of color that do not know what that term means in the particular LSAT construction of the test. And white students will. There is a demonstrated testing gap on the LSAT, the SAT, and the ACT, and unless you're willing to say that some demographic populations are smarter than others, which I am unwilling to say, then why is there a demonstrated testing gap? And who's deciding what the merit or excellence is? Is it an LSAT test? Does that make you meritocratic if you scored an excellent LSAT score? Or is excellence graduating from a certain place or a certain institution? And again, when we're talking about socioeconomic differences and opportunities that some folks have that others don't, then we get into territory where we're really saying merit equals wealth. Like if you have the wealth to, the reason that we do free LSAT instruction for the pathway program is because some people can't afford an LSAT prep program. And some people don't even know that there's such thing as an LSAT prep program. And so many of our students in the pathway program would take the LSAT blind because they haven't been guided or instructed as far as how do you get into law school, because they are not privileged in that way. And so for me, when I hear arguments about merit and excellence, I have to ask the question, to who? How are we deciding what merit is? How are we deciding what excellence is? And literally, if it's a test where we have demonstrated testing gaps, then I don't know that that's merit. I don't know that that's excellence. And so one of the things that's really critical, I think, for this conversation is to decide, or is to at least debate or discuss, how do we measure excellence? How do we measure merit? And how do you, to the qualification question of the founding writers, like we couldn't have excellence in 1787 because people were enslaved. And and if we're saying there that the only qualifications are in education, like I think we could have had a kick-ass constitution if we would have had enslaved people in the room talking about what their rights should look like. We would have had a more excellent constitution. We had women in the room, even though they weren't qualified because they weren't allowed to have an education or weren't allowed to speak or even have opinions, I think, at the time. So, so we really need to dig into what qualified means, what merit means, what excellence means, and who's deciding what that means on a going forward basis.
There's a great deal of that with which I agree. I do recognize that many of the standardized tests are, or at least have been, discriminatory, and that some of the results of them are questionable for that reason. And I agree as a normative matter that we should aim to eliminate those kinds of biases so that whatever kinds of metrics we use for important decisions not be affected by those kinds of biases. I don't agree that it was impossible to have a excellence at the time of the framing era for whatever reason. I think that the Constitution that was developed was, in fact, excellent, and that a lot of the thought and discussion at the time was excellent. I do, however, agree that any time that you have an artificial exclusion of a group from an enterprise, that you're apt to get less excellence than you otherwise would have. And so if we had a society that was more meritocratic than the 1787 society was, then presumably there would have been more opportunity to get an even better result than we did. I also agree that it's important to consider to have more of an in-depth discussion about what merit means in an individual context, but really what we don't need to decide that particularly for every industry that it might, for which it might matter. I can give some sort of examples, but really all we need to know is, to get us started, is race, gender, sexual orientation, ethnicity, and the rest, is that what we mean by excellence? And if it's not, then we can have some talk about how much we should care about the LSAT versus versus GPA versus prior experience or whatever else that we might think goes into merit. But unless we think that race, gender, and other kinds of demographic characteristics by themselves are what merit is, then I have a hard time saying that the way of achieving merit is to give a boost for people who have those demographic qualities, regardless of whatever other kinds of aspects of merit they have.
Thank you, Mike. Honestly, Mike makes some really good points, and I just want to, my co-panelist here to my right, I do want to respond to this comment about that was the only group of individuals that who were qualified to sit in a room at that time. So let's just rewind again. To be qualified, let's assuming it was this idea about education. Let's just take a wild guess. Who was the only group that had the ability to go and get a degree of higher education or get schooling or get an apprenticeship, right? It would have still been the white males, and the other groups would have been excluded. So you have all of these systems that were operating to exclude groups. And so it doesn't bolster your argument to say that they were the most qualified. They were the most qualified because the rules at the time to give them those qualifications excluded everybody else. So it still goes back to the heart of it is, and I do think Professor Domino's, his point, which is that we still ended up with a good document. Maybe if we would have had other groups included, we could have gotten a better document. Well, this is the United States. Why not get the best? And if it's about getting the best, right, and we have this fundamental aversion, or we have this fundamental problem with diversity and it giving us these inconsistent or unfair results, again, rip it down and let's start off with something new that would be better, right? Like, why should we be stuck with something just because of the history that we have in the country? Why not blow it down, get rid of those individuals who were privileged and were only in that room because of the color of their skin, and come up with something that's more fair? Like, if we really have a disdain for the consequences and these evils that diversity allegedly perpetrates, let's completely eliminate it. And so if I heard a conservative say that, I'd be willing to say, you know what, let's do this, right? But what it becomes to me is like, no, diversity and the evils that it perpetrate were okay when it benefited white men, but if it has any ability to benefit anybody outside of that category, it's an evil. And that's where I have a really, really big challenge, because the perspective isn't consistent. I'm a lawyer and I believe in rules and I think they should apply fairly. And when I hear someone making an excuse for why it was okay to bend the rule for this group but not for another group, that creates inequality, that creates unfairness, and that is un-American. And I also agree with Dean Cummings about how do we evaluate this concept of merit. Sometimes we look at these objective measures, and a lot of times it's really predicated upon wealth in America. And we know that the large amount of wealth in America is inherited wealth. And so, many of us and some of us have the opportunity, like when you start talking about a SAT, to have tutors for our children from the time that they're born. So of course we expect that they're going to do better, right? If you come from a family and you don't have access to those resources, then your child is less likely to perform at the same level. So I think that if we're really talking about leveling the playing field, it really is about providing more access.
Yeah, I'll start with just one point on Dean Clark's remarks, and we'll move into some comments about that Dean Cummings had about excellence in the world of standardized testing, which Dean Clark also touched on. I think we need to be careful that when we talk about problems with inclusivity, we are not promoting exclusivity. So when the commentary about the founders being the only qualified individuals, Dean Clark's absolutely correct. They were the only qualified individuals because there were exclusionary practices that said expressly, women are not qualified, blacks aren't qualified. And fortunately, as a country, starting with the 14th Amendment and then furthering through federal statutes, we have removed those express exclusionary practices, and they no longer exist. So I think I wanted to make that distinction as well. No one is promoting exclusive practices. And fortunately in this country, the express exclusionary practices have been eradicated. The next point I wanted to make was this notion that the Constitution was supposed to be a perfect document or the greatest document in the world at the time of its founding. The founders didn't believe that, and that's why they allowed for amendments. They realized it wasn't perfect, and they realized that times would change and that the Constitution would need to change with it, and therefore they built in a mechanism, I think a rather remarkable mechanism that's been invoked several times, many times actually, to correct problems with the Constitution or flaws in the Constitution. I don't think there was ever an understanding that it would be perfect. I do want to segue into this concept of excellence. I think focusing on, and let's since we're here at an esteemed institution that uses standardized testing, I'll focus on that. I think it's too narrow to say that excellence is, the demarcation of excellence is a standardized test score. Number one. And nobody is arguing that it is. But this notion that you cannot define excellence, or you really don't know what merit is, or who makes the decision, I don't know that that's accurate. This school makes decisions based upon objective markers as to who gets admitted and who doesn't. Now, there may be some subjective stuff as well. I'm sure there is. All institutions use it. But it's disingenuous to say that there's not objective standards that are used in any organization. Otherwise, nobody in here would either want to be part of the organization, or no one could seriously contend that a student that did not, bombed on the LSAT and had failing or near failing grades in college would be admitted into this institution. That wouldn't be fair. But at the same time, there are objective standards that were utilized by the admissions committee to determine whether that student should be admitted into this school. So I think that's one point I wanted to make about standardized testing and what standards are utilized and what it means to be excellent. Whenever there's a selection process, there are certain objective standards that are going to be utilized, and they always will be. And I don't think we should jettison those. But to a more discrete point about performance gaps, this is something that both deans touched on, performance gaps on standardized testing. I wanted to note something. The first is that what statistics show, this goes back to my point about socioeconomic background, what statistics show is that what is more highly predictive on what will result in standardized testing is income level. Okay, so when you take black students and compare them to their standardized test scores to white students of the same income level, where you have a doctor and a lawyer parent, they're basically the same. Where you become decoupled is poverty, where you're poor, and they're actually I don't want to say it's wasted, because I'm going to do it with my kids too, and everybody does it, where you're going to pay for your kids to have a tutor for these tests, but it improves the score marginally. The testing shows that students that get the tutoring don't, by and large, perform much better. So I think that it raises bigger issues as to why, why students of certain income levels are not performing as well as those that are higher, that are at higher income levels. And if we really wanted to address the root problem, we'd talk about that. I mean, two-parent households are going to perform. Your children's going to perform better. I'm not going to deride anyone. That's a single parent, and it's very laudable, and work your butt off. But at the same time, I'm just talking about from a statistical output perspective that two-parent household, two parents that are higher income level, generally speaking, I'm not saying in every instance, so please don't misunderstand my remarks, but these are the things that we need to be discussing. Even when we talk about justice, access to justice, a big thing comes up with DEI. It's like, well, the jails are populated more with black men, and that means the justice system is fundamentally biased. It's institutionally racist, and we're like, well, are they poor? And yeah, well, it's more likely that they're in jail because they're poor, because they couldn't hire the same access or the same level of attorney. I mean, look, if Bill Cosby didn't have any problem, ended up out of jail because he was rich. That's the bottom line. Guy was rich, so he was able to access a different level. Look, that might not be fair, but the reason why there was a different outcome for Bill Cosby as to a poor black kid from North Philly was because the poor kid was poor. He didn't have access to the same resources that Bill Cosby had access to. Both are black men, and two very different outcomes. So I think if we want to really get to the root cause of some of the things that I think the panel shares as problematic, I think we need to focus on more of the poverty issues and the income issues, and how come folks that don't have that are poor have a different outcome. And I think that poverty strikes everybody.
Can I just say one more thing?
Absolutely. I was going to ask, how would you characterize what you've heard?
I think that the initial piece that you mentioned, I think you make some great points there. The only thing that I would push back on a little bit is to say that this is solely based upon economics. And I'll give you an example. If you have a black man and a white man that are stopped on the side of the road, the black man is 2 times more likely to be killed. So are you telling me at that point that before the officers decide to shoot that black man, they're saying, oh, by the way, how much money do you make? Oh, you make less than this person, so now I'm going to kill. Like, at that point, there's an analysis of that individual's race, and race is playing a role, because at the side of the road, the officer has no idea how much either of those victims, or how much either of those people, whether they're white or black, are making. So I do think that there is an aspect of race that is playing out in that as well.
I mean, is that, I have no knowledge of any case where a rich black guy was randomly shot on the side of the road by police officers. Who is it? A wealthy.
How are the police officers making an assessment about how much someone? So I think that's a really big stretch, that you're saying that, oh, the officers that are engaging in this improper behavior and it results in death, that the officers say, yeah, I killed him because he makes less money.
Well, I think
that's a big stretch there.
The analogy, I mean, is that just a sort of a hypothetical, or
I'm giving you the statistics that black men are 2 times more likely to be killed than white men.
But that
doesn't.
The statistics on that, at least as far as I understand them, are the way that you set up the question and the statistics you said at the end are quite different ways of setting up the problem. That if you compare the percentage of, say, police-caused deaths by race of the victim compared to share of the population, that's how you get a statistic that says that black men are more likely statistically than whites to be shot by police. But it doesn't control for any of the other aspects of the police-citizen interaction or any other aspect of the demographics that we might care about. He mentioned income, but there can be others. If you might, this is not my primary area of study, but from what I have read, the indications are if you do control for all of those kinds of things, say in the same geographic area suspected of the same kind of crime, and you control for all the rest of the kinds of circumstances, that minorities and specifically blacks are no more likely to end up with a fatal encounter with the police than any other group. Now, I'm not vouching for that. I haven't run the studies and I haven't studied them enough to say something definitively, but it is not my understanding that between the white guy standing on the side of the road and the black guy standing on the side of the road, that the black guy is twice as likely as the white guy to get shot.
So I agree with much of what Professor Domino and Mr. Zimlong have just stated. I don't disagree with most of what they stated. It seems to me like there's common ground that could be built upon, and it seems to me like it could start at trying to solve poverty issues in the country. And it seems to me that we could, begin looking at, I hesitate to go into an area I know very little about, but it seems to me like we could do better at how we fund public schools than, as I understand, at least the last time I looked many years ago, was by property taxes. And depending upon whether you live in, Beverly Hills, where I did not live, although I grew up in that area in Southern California, Beverly Hills versus Compton, and if it's public schools property taxes, you're going to have very different educational experiences. That seems like a problem. So I think one thing that we could really think about is, how are we as one of the most successful, most wealthy countries on the planet not able to figure out how to ensure that childhood poverty isn't something that afflicts both rural, white, poor, and urban Black communities and Latino communities as well. So that's one thing that I think we could start talking about. As far as policing is concerned, what I would say is that we have just had fraught police community of color interfaces throughout our history. And that has been well researched and documented. I don't know the studies that Professor Clark is referring to, or Professor Domino, but I will say that one thing that I do know, and Professor Clark and I have spent a lot of time researching this, is that trauma is a huge indicator of adult success, especially childhood trauma. And as I've done my adverse childhood experience, my ACEs research, what has come up to us very powerfully is that Black and brown children suffer many more traumatic experiences as children than do white children. And if adult health outcomes are impacted by childhood trauma, then one of the things in the studies that Professor Clark and I uncovered is that if you have a certain number of adverse childhood experiences as a child, you are going to live 20 years less. 6 or more ACEs, you're going to live 20 years less than someone that has 0. And so one of the studies that Professor Clark and I have engaged is, do police traumatize children, particularly in Black and brown communities? And our research is not yet complete, but in our anecdotal interviews of Black police officers and others, nearly everyone that we've spoken to had traumatic childhood experiences with police officers. So it's a problem that we have in the country that that we need to try and get a handle on. And I think some of this goes to the history of policing. Some of it goes to some of the warrior siege mentality in policing. But what I would say is that it's clear that when children experience trauma, particularly at the hands of law enforcement, it leads to debilitating adult health outcomes. And we're just at the cusp of our research. We're going to put together a longitudinal study of police officers and begin to dig more into the interfacing between trauma and police behavior. But that's something that is worthy of research that Professor Clark and I, together with Judge Amy Johnson and Prosecutor Caleb Conrad, have undertaken.
Thank you all for your responses to the questions. We've got a lot of really great questions from the audience members, and so just trying to be mindful of time, I want to read this one. So one of the audience members asked, or they mentioned that a few of the panelists talked about rewarding excellence. But doesn't excellence depend on who writes the test, and doesn't this perpetuate a false sense of entitlement from where students from privileged backgrounds believe they are more capable than those who have overcome more obstacles? And how do we determine who sets the standards for a seat at the table, wherever that is, school, in the business, and in government? And so if you guys could tell us your thoughts in maybe 2 minutes or less, that would be great.
I touched on it, which is, it's a point well taken, that it's very tough to pin on what excellence is. And I don't think that when we talk about merit and excellence, we're trying to be saying, look, merit and excellence is these certain objective delineating factors. But again, it defies common sense to say that there are not objective factors that determine what excellence is. I think I heard one of the deans saying they were involved with sports law. Look at the world of sports. If I asked you who was a better player, right? Who's like an excellent football player? Like who's an excellent running back? Saquon, right? He's an excellent. Why do you say that? Well, because he had, he led the league in rushing, so that, there's an objective factor there that you can utilize.
He had the reverse fault.
Right.
Yeah.
So there's an objective factor there you can utilize. I agree. It's not incorrect to say that the writers of the tests determine excellence, because, the writers of your law professors write a test. They're going to determine if you can answer the questions on your test. That's going to determine excellence. There's class rankings in this school. It's going to determine by objective factors. So, it's a point well taken, and not every outcome of excellence is something that is a result of some standardized objective, but it certainly, I think, plays a big role in ultimately coming to the conclusion of what is excellent.
Another point for that is that it's come back to what we're debating, what we're trying to figure out. Is it appropriate to give extra credit to people for fitting the right DEI category? It doesn't undermine the idea that overcoming adversity is important, or having qualities that don't show up on an LSAT are important. Doesn't undermine any of that to say, well, then consider overcoming adversity. Don't just say, you were born with a silver spoon in your mouth to parents who were lawyers and doctors, but because you're black, we're going to favor you over this poor white kid who did have to overcome a whole bunch of adversity. But the way that the system works now is that whoever, again, for political or ideological reasons, whichever group we want to favor is going to get that boost just because of those kinds of factors.
What's interesting is I think both of you made great points, and I would be inclined to agree with you. But I'll tell you where I've heard some conservatives go a bit too far. Dean Cummings and I were at this Federalist Society event in D.C., and it was a great event. And one of the panelists had made a comment that, going back exactly what you said, Professor Domino, which is, we should evaluate people's experiences, or you should be able to evaluate, regardless of whether you're black or white, how you've overcome adversity, right? And so one of the comments was that after the Supreme Court's most recent decision in Students for Fair Housing, SFFA, the comment was, we should see less diversity. And that sort of undermines really the point that you're making, because SFFA, if you look at the opinion, it essentially says we can consider those life experiences that contribute to someone's, intellectual experience and how they will contribute to the organization. But this person's specific comment was that it should lead to less diversity. And I took a really, really big issue with that, because that wasn't the ultimate outcome, or that wasn't what the Supreme Court stated. And I think that if there was truly a fairness in evaluating all people's experience, because I like the underdog. I mean, to be quite honest with you, that is the essence of Delaware Law School, and that's the essence of Commonwealth. If you think about our phenomenal TAP programs that we have here, if you look at our LSAT scores are not what they are at Penn State or what they are at Rutgers, but I'll take my damn students over anybody in the country because I know how hard they grind. I got one young man that participated in our TAP program and didn't get into any other law school, came to Delaware Law School, went through the TAP program, fought. At the end of the first semester, he had a 3.67. He's sitting at number 4 in my class, and he's going to have any job he wants. I'm even put him out there. He's actually going to sit on the University Board of Trustees here because he's just been such an exceptional student. And I'm going to make sure that he gets whatever job he wants, right? That was a person that overcame, substantial circumstances and put himself in a position to do very well. That's what we are about here. And I think that regardless of whether you're black or white, that type of experience is rewarded here, and it should. But I don't think that just because we focus on those things that it should mean that there's less racial or gender diversity.
I'll just add quickly, and I don't disagree with anything that's been stated, is that as the dean of a law school, what we're looking for is indicators that students are going to succeed. They're going to come in and get good grades and pass the bar exam and be really good attorneys. That's what we're looking for. And so for me, that's a white student, black student, Asian student, brown student that has overcome adversity. I want that person in our class. I want that person that has shown that they can get it done, that has the grind. Sometimes, we get very high LSAT scores that apply here. That doesn't necessarily mean that you're going to succeed. That just means you can take a standardized test and you can do logic and reading comprehension on a going forward basis. But the Students for Fair, SFFA, said to Professor Domino's concern, checking the box is unconstitutional. You cannot just check a box and say I'm a black student and get that as a plus to get into law school. So that is the law as I understand it. But you can say, I overcame adversity. I was racially discriminated against, and in so doing, I had to overcome and achieve in ways that make me more willing to work hard and grind than maybe the next student. So for us, I think I can speak for Dean Clark here, we're looking for the holistic person. We want to see someone that has shown they can succeed on a standardized test, but also that they had challenges that they were able to overcome, because at the end of the day, what we're producing are excellent lawyers, and that's what we want to see from all stripes, from all races, backgrounds, what have you. And so that's, I think, important to recognize that in this world of sort of really neutered affirmative action, we're still looking for individuals that show us that they can succeed, and overcoming hardship and overcoming poverty and overcoming racial discrimination are ways to show that you can get it done and that you can achieve. And so we're proud that that's a part of the fabric of our law schools.
And that's diversity, right? Like that is diversity. And I mean, that's why I have so much challenge with this concept of like that DEI is like a bad word, because everything that Dean Cummings and the rest other panelists have said is like, if you're talking about like the fact that you've overcome the challenges, I love to see those people in my classroom and in my law school, and that is diversity.
So I'm curious, Professor Domino and Mr. Similong, how would you guys characterize what you just heard between Dean Clark and Dean Cummings?
I don't think that there's a disagreement about that. We're all in favor of focusing on, or at least giving consideration to those kinds of qualities. But remember, the only reason that we're at that point is because the law schools lost in the advocacy for what the kind of affirmative action programs that they wanted to do. What they wanted was check the box kind of programs. The UC Davis program that started off the Supreme Court's consideration of affirmative action. What they wanted was, we got 100 seats in this medical school. We want 16 of them to be reserved for minorities, no matter how good their qualifications and no matter how good the qualifications of the whites who apply for the other spots. That's what the schools want to do. They tailor if we've gotten to the point where the law schools say, boy, that was a terrible idea, we really should focus on the individual more, then terrific. Then we have agreement now, and we're all for that. But that's not what the University of Michigan was doing in 2003, and it's not what Harvard wanted to do 2 years ago.
Yeah, whether Dean Cummings realized it or not, he made a far more eloquent argument than I ever could against DEI based upon his description of what he was saying, how the students are admitted now, post Students for Fair Admission. Not surprisingly, that's why he's more articulate. That's why he's the dean, and I'm just a lawyer. But that's it. I mean, as I said when I began my remarks, diversity as it ends is not controversial as how we get there, and that's what Professor Dominio and I are saying, is that, look, if you're just going to say we need this many people in this class and we're going to give a plus to this race and a minus to this race. Keep in mind, students in fair admission, they were giving minuses to Asian students. They were saying they were racially classifying Asian students in a negative way and saying that, well, there's too many Asians here, so we're going to ding them on this, ding them on that. The panel, I think, here is in unanimous agreement that type of behavior is wrong, and that's the behavior that was litigated in Students for Fair Admission. So again, if the goal is to achieve a diverse student body and you do it in the manner that Dean Cummings articulated, we can all go home because we all agree. The problem is, as I said in the beginning, is how we get there.
Back to that really quickly. I love that we're all in agreement on this point. I don't want to characterize UC Davis necessarily as wrong, right? In the 1960s and 70s, they were trying their best to figure out a way to lift formerly excluded black students into medical school. That's what was happening in Bakke, is UC Davis was like, okay, we have excluded this class for a century. Like, what can we do to lift them up? And so their attempt with a quota was deemed unconstitutional by the Supreme Court, but I don't want to characterize that as UC Davis being wrong somehow. They were trying to figure out a way, right? What we needed to do was just Herculean catch-up efforts on education and folks that had been formerly excluded. We needed aggressive affirmative action, in my view, at that point, because we had excluded black and brown people and women for so many years. Like just removing the obstacle, you still have unqualified folks that you're like trying to figure out how do we get them equal opportunity. And I just have done some comparative affirmative action studies. Some kind of Brazil and others, they have quotas. I mean, their attempt to make their racial discrimination right has been quotas, where they've been lifting people into classes that are maybe not qualified because of educational background. But I don't disagree with Professor Domino at all as to his characterization of Bakke. I just want to say that our Supreme Court found that unconstitutional. UC Davis was trying something, trying to figure out a way.
Oh, I'm sorry. Yeah. I do want to say this because I do think that there is some agreement here on the panel, but I do think that we will not be able to really come together in a uniform way until this one issue is addressed. And so I think all of us are probably sports fans up here, at least that's the sentiment that I'm getting. So I'm going to sort of make an analogy in the context of sports. And if you think about life is a race, right? And so if you think about, let's assume that we're running a relay. And if we're running a relay, you have, let's say, white males there in one lane, you got, different races and different ethnic groups in each of the lanes. And so let's assume that we all start this race, but then there are groups that are told, you're not even allowed in the stadium. You are not even allowed on the track. You just cannot come in because of who you are, because of your gender, because of your status. Gun goes off, the race starts, right? White males, they're taking a lead, they're running a few laps, and then it's like, you know what? That was unfair. So what we're going to do is we're going to allow just a couple of groups into the stadium. Now, keep in mind, the race is already going on. So now you add some additional groups, but what you do is you put hurdles in their lane for them to jump over, right? Now, again, the white males have no hurdles. They've already had the big lead. And so now the other groups are able to run, but they have these additional hurdles that they have to jump over, right? So now, okay, it's like, you know what? That was unfair to keep certain groups out, and it was unfair to put those hurdles in there. So now let's remove the hurdles. Everybody is allowed. But what has happened is the group that was allowed first, without any obstacles, that was allowed to start at the proper time when the gun went off and didn't have those additional hurdles to jump over, has this lead. And the only reason that they have that lead is why? Because of who they are, the color of their skin. It was a privilege. So sometimes I don't understand why people are resistant to calling privilege, right? That was a privilege, and the privilege was being white in America at that time. Now, that doesn't mean that they worked less hard, but there was a privilege associated with it. How do we deal with those other groups that are consistently behind until we have a discussion about how to make that fair? And it's not fair to just say that is gone. Let's not think about that. Because if you are a member of one of those groups and you hear that, each generation that baton, each time that baton was passed, that was to a new generation. And you start the race behind. And now to say that there's complete fairness makes it very, very difficult for minority groups to accept that perspective, or some people within minority groups.
If I could just address a quick point from Dean Cummings, is that, at least I don't read Students for Fair Admission to overturn sort of Bakke and its progeny where there's a compelling state interest to remedy past discrimination. But that's not what was issued there. And in fact, that remains the law, almost to a fault, I think, in some respects. But that remains the law. That remains. So if there are institutions where there is a history of discrimination and the state wants to remedy that history of discrimination, I don't think there's anything wrong with that. But I think what we've seen is we're not in 1960, and we're not trying to it's not the same situation. So, and that's, in fact, I think. Justice, in Regents, okay, look, I'm going to say, I'm scrambled. Sandra Day O'Connor, when she said, well, I have to do this for 5 more years, in the Michigan case, I'm sorry. But, so anyway, I digress, but okay, sorry, Professor Dominio, I interrupted you.
So just a couple of things on the relay race point and on Wally's thing. Yes, the court has drawn a distinction between finding a compelling interest in remedying specific acts of discrimination by a particular institution, but the court has not found compelling interest in making up for broad societal discrimination, which is what Dean Clark was talking about. The diversity rationale is not supposed to be addressing that problem. So however persuasive it is, it's not DEI, because DEI is based on this idea that we need to bring in a diversity of backgrounds or something. It's a totally different argument, which I think is more persuasive than the one that prevailed, but it's important to note that it's different, I think. And the other quick thing I want to mention about the relay race analogy is that it's not, we have had a history of immigration into this country that has occurred from the time when the first settlers arrived and continues through the present. That I think it's unfair, inappropriate to say that the Asian immigrant in 1990 has to pay for the debts of white slave owners 150 or more years before that. And from my own personal family background and of history, that zero of my ancestors were in this country prior to 1890. Now, did we get some kind of advantage by being white relative to the kind of discrimination we would have faced had we? Sure, yeah, of course. But looping every white person together, or really any non-black person together, as having some kind of privilege of not starting behind the relay race because of the harms of slavery, I think it just loops in too many different groups of people who are not having the same experience, don't have the same kind of inherited wealth. And again, I go back to the poor white kid who does really well on the standardized tests and the grades and everything else, but he's locked out of school and locked out of the jobs because the rich black kid gets the extra boost from the affirmative action.
I would just say, Professor Domino, I think I agree with you. I completely agree with you about diversity and what you said. And my point about the race and my point about is a bigger point, to the extent that I think that we're going to continue to have this discord until that issue is addressed. I also agree with what you said. I think it's just like the underlying elephant in the room, regardless of. But you are absolutely correct. I also agree with your comment, which is like when you gave the example of the Asian immigrant in 1990 or whatever, right? Like, I agree that person shouldn't be penalized for the past atrocities that were perpetrated against people in the United States. I would agree with that. And I don't know that I've never suggested that any particular group should be penalized, right? Like, if we think about the harm was perpetrated by the American government, like maybe there's a discussion about reparations, right? If there's a discussion about reparations, then I do think that you have a stronger argument to say, okay, this is something that we've sat down, we agreed that this is the fair point, this is how we balance that inequity. Maybe that's discussion. I think that's why people talk about this concept of reparations, because that doesn't individually penalize the specific groups that you're highlighting. So I think that that's part of the discussion, but it still is a challenge when you start to really think about one of the things that Professor Dean Cummings and I write about, and we spend a lot of time talking about, is just if you think about wealth in America, if you think about this concept of Black Wall Street, there were opportunities for African American communities and minority communities to generate wealth and then to pass that wealth down to their descendants. But there were rules and laws that operated to prevent that from happening, like that took their property away from them unlawfully, or rules that were in place that prevented African Americans and slaves from owning property, even though they worked really hard. So I think that there are these evils that I do think we need to address. And I agree with you, it wasn't DEI, but I think that's sort of the underlying rule, because I think that minority groups are like, there has to be something that helps, offset this wrong, because this wrong continues to play out in our lives. Like, there are evils that continue to persist in our communities, and these are historical evils.
Thank you all for
I'm going to take a dean's prerogative. before Tara shuts us down, let me ask, how did we do? We tried to model a civil conversation over something difficult that I think we have some strong disagreements, but a lot of agreements on. How did we do? Yeah?
I thought you guys, sorry, I'm screaming at you, but I thought you guys did fantastic, and I really appreciated the respect that I felt between all panelists today. I think that that's something that really lacks in social conversations, whether it's at school or you're at home with family. I know when I'm with my family, conversations do not go as smoothly as they did here today, so it is nice to see that. And so I guess my final question for you guys, and it is 2:01, Professor Domino. I know you had to go straight right at 2, but we're in it, so.
Criminal law students will go on for.
Oh, okay. Okay. So I guess just to kind of recap, panel one, we talked about engaging in practical pluralism, and then we put that in action with panel two, right? To talk about a pretty controversial topic and to get different perspectives on it. So I'd like to end today's session by asking how you think the legal education or even just social education can prepare students or general citizens on how to navigate DEI-related conflicts or controversies, whether they are doing so as advocates, decision makers, or just citizens. How do they practice having conversations like you all just did?
I think if you want to encourage conversations like this, then you have to, people respond to incentives. That if there is a danger in having a conversation like this, if someone who goes into a conversation like this feels like there's a whole bunch of landmines, and if I step on one of them, I'm going to get doxxed, or I'm going to get fired, or the Senate Judiciary Committee is going to vote against me, or whatever it is, then you're not going to have these kind of conversations. So there has to be an openness to have them, and a willingness to tolerate the people who have the opposing views without a kind of reaction of shutting someone down who says something that I didn't like, or something that made me uncomfortable, or something like that.
I completely agree with Professor Domino. I think we have to do a better job as law school administrators, as professors, to encourage discourse and just encourage discussion and encourage the debate, regardless of what side a person is on, creating a safe space for students to say, I have this really liberal perspective and I have this really conservative perspective. And I'll tell you, when I'm a professor, I bring in a can of gasoline, and when we get on these hot topics, I just throw it, and I want them to go battle back and forth. And if they don't battle back and forth, I will take these really strong positions on either side to force the conversation. And so, because I think it's really valuable for students to hear that perspective. There was one school where I taught, and it was an extremely liberal institution. So I would take these really, really strong conservative positions. In fact, in class with Dean Cummings, and afterwards, he's like, Todd, what the hell are you doing? Why did you say that? That makes no sense. But I was really pushing my students, and I always tell one of the best compliments that I ever received was when one student said, Dean Clark, I don't know what's up with you. You're like some white CEO. And I'm like, dang, I'm doing a really good job, because I was able to be something that they didn't think I could be, because it was all with the goal of helping them, see the world in a different perspective and challenge their viewpoints. And I think that's probably something that's consistent with all of us. I don't really care where you come out on the perspective. I do care that you stand up for what you believe to be your moral imperative. And so I want to encourage students to do that, regardless of what side, and let them know that whatever side they're on, I'm going to support you because you're my student.
I think it's easy for us to do it because we're all experienced lawyers, and law is an adversarial profession. It's really unlike any other place where you're like literally arguing with somebody every single day. Many times in private practice, you're arguing with people that you know and you're friends, but you have positions, you're representing clients. And I'm not sure that any other industry is like that, where it's primarily politics, but primarily, argument. So I think it's a challenge. I'm not a behavioral psychologist, so I don't want to say what my recommendation would be to navigate these discussions, sort of outside of those that don't have legal training and a legal mind, that are used to and receiving critical analysis and hearing positions that are adverse to theirs, and not maybe taking it personally. I think as we have these conversations maybe in the broader context, it becomes challenging because people just aren't wired that way. So. That's one of the things I think, is something as a lawyer you shouldn't take for granted, is your ability to think critically and receive criticism without making it personal or letting your emotions take the best of you. It's something you should take very seriously.
So I'm sensitive to Professor Domino needing to get back to class, so I will be very brief. I like Mike Domino, and I like him even more now. I had no idea how this conversation was going to go. Now I feel like I should have required the school to be here so that everyone was sitting and hearing a civil conversation. I like Wally, and I haven't even met him formally, but I like his perspective and the way he had the discussion today. As dean of this law school, it will be really important for me, for our students to have civil disagreements and to be able to have these conversations and to understand that we are all, if we could assume good faith in each other and be good to each other, then I think that we can overcome some of the, what I think is political nastiness that's sort of encompassing some of these conversations that are happening, and that would be my hope. So I'm grateful to each of these men for being here today, and for the first panel, each of the women that sat on that panel, and Dean Hussey for doing it. And I'm really impressed with Eli and Tara for the work that they did and how well they navigated as students this program today. So thank you all for being here. Tara?
Thank you all, and thank you to all the panelists. This was a great conversation, and honestly, it felt way too short. I could keep going. So I know you all have things to get back to, so thank you. And have a good day.